this matter, my lord. There is law officer.
To mention on Monday, why you are mentioning today?
This is regarding transfer order, my lord. I have mentioned on Friday, as it is expected to appear on 10th. Your lordship mentioned
Mention before which bench?
before lordship.
Yes.
Your lordship directed to mention next week. So I am mentioning this matter.
I directed to mention the matter on Monday. You did not mention the matter on Monday.
I have some problem on Monday, my lord.
So don't make wrong submission before this court. Mention on Monday. I will consider.
Bye.
Sorry. Yes. No, today is not the date for mentioning. Yes. Sorry.
Order of the division bench, the matter.
Sorry, I will consider it. Mention on Monday. Today is not the mentioning date. Unless and until it is extremely urgent.
নেবেন না বলছেন না সোমবার নেবেন
Yes.
Matter, my lord, I am
Mention on Monday. That is the mentioning date.
mentioning on behalf of the state respondent. My lord, this matter was taken by the lordship, by his lordship Aniruddha Bush, my lord, on and his Aniruddha Rai. And his lordship was pleased to pass an order, passing an interim order, and directed the matter to appear on 18th. My lord, I am praying let the matter be appear on 18th.
Why you are mentioning today?
My lord, because due to change of determinant, and if the matter is not appear on 18th, my lord, then we are suffering from.
Mention on Monday. 18th will be on Tuesday. Mention on Monday. Yes.
My lord, I mentioned these two matters on my lord, Monday.
Today is not the mentioning date. Unless and until you cannot wait till Monday, you can mention.
My lord, on Monday I mentioned.
Every day mentioning I do not permit.
Monday I mentioned your lordship directed me to serve copy of the notice to the other side and come on to Wednesday. That's why I come before.
What is the urgency?
Urgency is that, my lord, the recruitment process. It is this honorable court was pleased to direct the petitioner to before appear before the Composite Hospital BSF, Bidhannagar. He appeared, declared fit. My lord Justice Aniruddha Rai was directed to given a liberty to mention this matter after completion of medical examination. That's why.
Mention on Monday.
extension of interim order interim order expiring on Monday.
So why you have not mentioned on Monday, last Monday?
That will be too early.
Yes. Why you have not mentioned? We will next Monday for extension.
Your Lordship, my matter was an application on top on the 12th of November today itself, but it has not come in the list. So urgency is that the second so-cause has been issued in a departmental inquiry.
Your application was at the top of the list when?
On 24th September. Would you like to see the order?
Yes.
So
yes. Then what happened?
And my serial number has not appeared, not come in the list, and the matter is urgency because if my matter is not heard, second so-cause after second so-cause, discipline authority may take the final order and then it will become infructuous. So kindly allow me to mention today.
What was the order passed by the court on 22nd of September?
24th. The learned counsel for the applicant, since he is addressing another court.
Give me the order. But on 24th, accommodation was paid for on behalf of the petitioner. It is recorded in the order. But matter could have been heard on 24th September. It was not heard since accommodation was paid for on behalf of the petitioner applicant.
Can you please grant another any date?
No, it was fixed for hearing on 24th. Why accommodation was paid for?
The advocate could not appear.
So it will not come according to your sweet will.
My career is at stake.
And I do not take application on Monday. What is the urgency?
Second so-cause has been issued, and after that, The final order will be issued. So second show cause I issued on
Have you
1st
given reply to second show cause? When second show cause was issued?
1st September.
1st September.
Yes.
So you must have given reply to the second show
I've
cause.
asked for some time and then there was no reply.
Whether you are appearing for Coal India? You are, so second show cause notice was given. You must have given reply to the second show cause 1st of September. In the meantime, 3 months have passed. September, October, now we are in the November 12th.
So I'm
2.5 months have passed.
I'm
So have you given reply to the second show cause?
I have asked for the time.
So they have granted time.
Not yet.
Not yet.
Not yet. No communication for that.
Visual application, it will appear on 22nd November.
Thank you.
I am mentioning one matter, my lord.
Today is not the mentioning date.
It is urgent matter. Today it was
What?
held. Today it was scheduled to be listed as today.
What is the urgency? Tell me.
It is not in the list, my lord.
What is the urgency?
Let it appear in the list, my lord. Then
Mention on Monday. You have to satisfy me on the point of urgency.
today it is fixed for.
Maybe I am not accommodating unless until I am satisfied that matter is really urgent. Mention on Monday. Please call the list.
Item number 1.
As per the direction of your lordships, my lord, deficit court fees has already been deposited, ma'am.
Yes.
My lord, in this matter, my lord, petitioners are, my lord, appeared, my lord, in the selection process of primary teachers recruitment of 2022, my lord. My lord, where, my lord, at the time of recruitment notification, my lord, B.Ed from DLED from NIOS and, my lord, DLED special education, B.Ed are the requisite training qualification. Those persons who are having those qualification, any of those qualification may apply online in the portal for participation in the selection process. Petitioners having both the qualification, my lord, B.Ed as well as DLED from NIOS, 18 months DLED course, my lord, indicated in their prescribed form, my lord, as B.Ed candidate. Subsequently, my lord, after a long journey, my lord, Honorable Supreme Court in one matter, my lord, held that the B.Ed is not the appropriate training qualification for the post of assistant teacher in primary school. And subsequently, DLED from NIOS was also, my lord, directed as the requisite training qualification. Those who have completed their DLED course from NIOS prior to 2019, they will be considered as and
they were in service.
They are in service.
Two conditions are there.
Conditions are there, my lord. Now, petitioners at the time of filling of their forms, they have indicated B.Ed. Subsequently, after the Supreme Court verdict, my lord, B.Ed qualification was, my lord, declared to be null and void for the purpose of, my lord, primary teachers. My lord, so, my lord, petitioners having both the qualification, they are only praying for migrate from B.Ed qualification to, my lord, NIOS DLED qualification. On the similar circumstance, persons came before this honorable court, and the honorable coordinate bench, my lord, passed this judgment My lord, on the last occasion, Mr. Vishwas, on behalf of the West Bengal Board of Primary Education, intimated your lordships that they have filed appeal against this judgment. But I have found that order has already been complied. My lord, entire portion of the order is very important.
অ্যাপিল করিস নি? ও বলছে তো অ্যাপিল করিস নি।
But this court has passed a judgment.
That is subsequently. My lord, I want to, my lord, give answer to the query of your lordships, which was asked by your lordships to Mr. Vishwas on last occasion, that whether any of the order directing to switch over from DLED, B.Ed to DLED has been, my lord, carried out or not. Mr. Vishwas, my lord, intimated your lordships that none of the orders has been complied. Rather, they have filed appeal against all those orders, and series of matters are pending before the division bench. My
No,
lord,
no, in the meantime, in the case of Pompa Dattodhar,
I have annexed
it has
this.
been, this order has been complied with. by the
Complied
court.
and
And
in Pompa
verification has been
Dattodhar,
made.
my lord, I am also the writ petitioner in Pompa Dattodhar. I am also the writ petitioner in Pompa Dattodhar, one of the petitioners.
Yes,
In series of matters was disposed of by your lordships.
so therefore, if it is verification is done, then why again you have come?
My lord, when they have published the verification list, petitioner's name does not feature in the verification list. Only two petitioners. All the candidates are called for verification. So, my lord, only these petitioners are not.
Then you have to file a contempt application.
My lord, after
Because issue has already been decided in case of two petitioners. Why again you have approached?
my lord, because my lord, subsequently, my lord, they have, my lord, published the one list of verified candidate called for who has called for verification. My lord, if your lordship kindly turns to, my lord, the page 89. Substantial compliance of your lordship's order. So therefore, contempt, my lord, is not maintainable, my lord.
Yes, page 89.
My lord, on 10th of July 2025, in compliance of the order of the Honorable High Court, Calcutta, passed on 13th of
কোনটা পম্পা দত্ত?
June 2025 and 17th of June 2025, such and such in Pompa Dattodhar, such and such. My lord, they have called for the candidates.
Instruction database NIOS application need BEd application. Let them show that he has applied NIOS. যে সুইচ ওভার যখন করে দিয়েছিল, যে করেছিল ওইসব কেস ছিল, সুইচ ওভার ওদের অ্যাপ্লিকেশন ছিল
না, এই জাজমেন্ট পম্পা দত্ত ধর,
এই জজ সাহেবের জাজমেন্ট।
সেটা কই?
আচ্ছা, 90
এগিয়ে বলে দিচ্ছি। 89 তো অন্য কস্টেট,
আমি বলে দিচ্ছি, বলে দিচ্ছি।
আরে বল, পেজ বল। কত? কিছুই নেই তো, তুই এটা কত?
Yes, 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 list is
Annexed,
enclosed.
appended. My lord, from the list, our names are not featured in the list, my lord.
Names of the petitioners, all petitioners.
Here, my lord, two petitioners. Rest petitioners' names are there, my lord. And on query, they have intimated, since we have
So both
indicated.
the petitioners were parties to the to the petitioner, to the petitions which were disposed of by this court on 13 June.
Yes, my lord.
ও থাকলেও তো হবে।
Subsequent
So
order.
do you have any information that why your names were
Yes,
excluded?
my lord. My lord, on query, my lord, the West Bengal Board of, from the office of the West Bengal Board, my lord, we have intimated, since we have indicated B.Ed as our training qualification, therefore we have been excluded from the list. My lord, unless they also
Now
specify.
you have at the threshold you have submitted that this is an selection process of 2022. In the advertisement, it was indicated that DLED, B.Ed qualified candidates were eligible to apply.
Yes, my lord.
Now subsequently, B.Ed was debarred by virtue of the order of the Supreme Court. Now where is that advertisement
Yes, my lord.
indicating that B.Ed candidates are
Yes, ma'am.
also eligible to apply?
My lord, if your lordships kindly turns to page 30, annexure P2. My qualification, serial number 3B. Serial number 3B. The candidate shall possess minimum educational training qualification as prescribed by the National Council for Teachers education prevailing as on date publication of the recruitment notification, TET qualified candidate who are undergoing DLED, D.Ed special education, B.Ed training for the session 2020-22 and who having qualified and DLED, D.Ed special education, B.Ed training part 1 examination from session 2020-22, they will be given opportunity to participate in the recruitment process to be initiated by the board. So, my lord, for the fault of the authority, my lord, no candidate should suffer. My lord, in the case of
So you are submitting that as B.Ed qualified candidate, you applied. It doesn't
Applied.
make any difference. Doesn't make any difference since B.Ed was one of the qualification training qualification which was acceptable in terms of the notification
At
dated
that point of
29 September 20.
at that point of time. Subsequently, after verdict of the Honorable Supreme Court on 4th of April 2025, my lord, in DLED from NIOS is also, my lord, valid training qualification, and pursuant to the direction of the Honorable Supreme Court, some
So if you had DLED qualification, why you did not disclose it?
my lord, at that point of time, my lord, DLED from NIOS is not the valid training qualification because one
Yes,
notification-
Mr. Shanna.
And exactly similar issue has been dealt with, my lord. May I certain paragraphs, my lord?
Yes, yes. Order dated 29th February 2024.
Yes, my lord. On Nesha, my lord.
Yes.
My lord. My lord, the fact, para 2. No, আপনারই করা। The petitioners before the court can be suggested into segregated to two categories. Petitioner number 1 to 7 possess B.Ed degree as also diploma in elementary education DLED issued by the West Bengal Board of Primary Education. The petitioner number 8 to 15 possess the DLED degree issued by the National Institute of Open Schooling NIOS as the diploma from the West Bengal Board of Primary Education. This is the
So you are coming under the first category.
first category.
Yes.
Malad, then entire issue has been Malad discussed and ultimately Malad from page 31, Malad para 31,
Paragraph 31.
31, page 10, internal page 10, the court
Just a
Onnesha Das.
মানুষ তোকে নিয়ে আসছিস কেন?
এই যে তার কমপ্লায়েন্সে আপনি রাখিয়েছিলেন
আরে কি কম জানি না এভাবে
এই
বললে।
সেম আমি বলেছি
এটা কি এখানে দিয়েছো?
না না
এটা কপি দাও না, বুঝতে পারছি না এটা কোনটা। অনেকগুলো মামলা হয়েছে না?
এইভাবে বললে হয় না, তবে তো দেখানো তুমি তো বুঝতেই পারছি না।
আরে এটা তো এখানে কোথাও নেই, এটা তো অধ্যয়ন করে তুলে দিতে হবে, আমরা জানবো কোথায়।
এবারে অর্ডার হয়ে থাকলে তুলবে না।
হ্যাঁ, তা সেইটা না দেখলে আমি বুঝবো।
দেখ আগে ঘর প্রান্ত ডাকছে বোধ হয় উপরে ধরে ফেলে না এটা করবি তুই ওখানে গিয়ে। তোর বলছিস কেন এটা দেখুন একটু কনফিউজ হয়ে যাচ্ছে এখানে কি হচ্ছে অ্যাকচুয়ালি কোথাও রং আছে তো। কনসিডার করি এটাকে কনসিডার
Yes, yes, Mr. Sharma.
And subsequently, order has been complied. That order,
Yes.
no appeal filed.
Yes, Mr. Sharma.
Well, I'm a little bit of confused. I'm personally, frankly saying. Well, I find here he applied as B.Ed candidate. Well, there is no provision in law, neither in the recruitment process for change of qualifications. So he cannot
The
change.
court has allowed it,
Well,
and we have complied with
proper
order dated 29th February 2024.
May I, well, that's
Identical issue.
of your lordship's order.
No,
That's
the order of Justice Mantha.
No, my lord, I tell you, lordship, this is if, as far as now this changing over, is appeal still pending and the appeal is my lord,
Very well, subject to result of the appeal, allow
we
these
have
two
not
candidates.
allowed anyone according to
No,
my
no, but
study.
in terms of the order, you have allowed. In Onnesha Das and others, you have allowed. Come, please go through the order of the coordinate bench passed on 29th February 2024. But there is a logic in it, Mr. Sharnal, since you are appearing in this matter, because at the time of in the recruitment notification, it was clarified that TET qualified candidates who are undergoing DLED, D.Ed, special education, B.Ed training, or who have qualified DLED, D.Ed, special education, B.Ed training part 1 examination will be given opportunity to participate. Now, it is observed by the coordinate bench in Onnesha Das that suppose a candidate is having DLED as well as B.Ed. According to the board, yes, after the law laid down in Jaivir Singh, B.Ed is not the valid qualification for being appointed as a teacher in primary school. Now, but it was not the situation at the time of issuance of notification dated 29 September 2022. Then the candidate having DLED as well as B.Ed would opt for that training qualification in where that candidate has higher marks.
Well, it's for him to choose.
Higher
His
marks.
choice.
And that was chosen by the candidate and it was indicated in the application form. In the meantime, there was alteration of situation by virtue of the order of the Rajasthan
Here
High Court,
point lies.
Rajasthan High Court as well as Supreme
No,
Court.
here point lies.
Now, why-
Everybody knew that the B.Ed qualification question is pending. Knowing that he has
Now,
chosen,
why
why he
candidate
should be given the benefit?
will be pitted against odds.
Well, that,
And when one group has already been permitted to switch over.
that's I'm not permitted. I think all the matters have been appealed against. And
Have you
that
obtained
it
any
was
order of-
concluded before Justice Sain.
Have you obtained any order of stay? Then I can consider. Otherwise, I have to follow the order which has been passed on the similar issue, exactly on similar issue on Neshadas.
I tell you, Onnesha Das is factually another different.
What
Here I
different?
tell you, lordships,
How it is different?
where I am not wrong, B.Ed to DLED or DLED to B.Ed.
No, it is B.Ed to DLED.
B.Ed to DLED.
Yes,
And here your losses.
B.Ed to DLED.
No, I tell you losses. This is DLED through NIOS. He knew that, where that I tell you losses what happened. In that point of time, they were undergoing DLED. Here he was not undergoing. He had completed both. Choice was of him, not for the board.
But in the similar
But
situation,
having exercised choice, can I
give a copy
alter
of this
election?
order to Mr. Sharnal? Mr. Sharnal, please come to paragraph 2.
কেন আবার আলাদা মামলা পয়েন্ট এক আলাদা মামলা বলে হয় না এখানেও সুইচিং ওভার দ্য সেম থিং এখানেও বাট ভুল বলছিস
Mr. Sharnal, paragraph 2.
গিভ মি এ ডেজ টাইম লেট মি আই এম সরি নো এইভাবে অ্যাসিস্ট করা যায় না কোর্টকে নো না করলে কি হয়েছে কি জ্বালা
Similar situation.
Let me consider. But my lord, we are fighting against tooth and
Yes,
nail.
if
We
you are
will go
fighting
up.
against, but if there is no stay.
No, no,
then
I tell you,
this
losses,
order is
I tell
binding
you,
upon
losses,
me.
no, no, stay was not granted because by day this was being heard. It was concluded, but it was not made part heard. Determination changed. The Justice Sen recorded in the order, it was substantially heard.
Very early.
Go before the, let me I explain. Go before the Chief Justice and get it assigned. Then they thought probably Justice Sen against them, views of the division bench. They didn't agree. Then the matter went before Justice Chakraborty. This is the situation.
My lord, kindly turns to my lord, para 6 of the judgment. Division bench, exactly similar, another issue. Division bench allowed, my lord.
No.
That is against interim order.
Meanwhile, my lord,
That is against interim order.
Sarkar, my lord, honorable division bench presided over by Honorable Justice Subroto, my lord, Talukdar, my lord, allowed the, my lord, dismiss the appeal preferred by the West Bengal Board of Primary Education and thereby allowed to switch over from DLED to BEd.
Justice Tolgul.
That is Justice Tapoboto Chakraborty against the interim order. Well, no, this is interim order. You do let us take against the
So,
final.
Court, yes, since you are submitting, yes, board is fighting it out before the division bench. But since as on date, the situation is this, that this switching over is permitted, and there's a logic in it. There's a
Malad,
logic
that's
in it.
Malad, I'm trying.
I have marked it. Please come to paragraph 23. You will please consider this, Mr. Shannath. Paragraph 33, not 23. West Bengal Board of Primary Education also cannot evade responsibility for the fiasco as they have illegally permitted BEd holders, DEd NIOS holders, and in course DLED persons to participate in the recruitment process. Naturally, the candidate chose the degree in which they had the highest marks as the basis of their application. Because at that point in time it was not known.
That's my point here, your lordship. BEd was challenged. Every court passed an order subject to the result of the SLP. He applied Malad subject to the order of the SLP. Having lost in the SLP, how can he?
But how you can ignore your...
It doesn't mention the entire part of it.
But how you can ignore your own notification dated 29 September?
Malad, 29 September, because I am bound by NCT.
Why this was done?
Oh, this is, I have to follow the NCT.
So therefore,
now, Malad, basic.
Today,
then
the situation has to be considered based on your notification dated 29
Lord,
September
even if you lost,
2022.
Lord, that would be subject to the SLP. SLP, they lost.
Yes,
so they have to lost here also.
But that's why if they have they lost, in the meantime, if situation is altered, and if it is an admitted position that on the date when application was made or on the date of notification, a candidate is having DLED as well as BEd, and BEd was opted. So in view of change situation, why this switching over is not permissible?
I cannot go on arguing with the court. My point is that when BEd was there in the notification as well as
what can be done? You have to argue with the court. It's a vocal court.
No, that's I tell you, lordship. That
is the problem.
It's good for us. It's good for us so that I can read the mind of the court. No, my point is that every court is missing that. NCT notification was in question. No, we had as a board we have to follow it. Pan India notification binding. Now, when he included it, there are other candidates who moved this court. Then the court passed an order, allow them subject to the SLP. Then what would be the result? They filed it in the BEd qualification, they filled in the form with the SLP. They lost SLP. How can they ask for changing? No, they are not sucking thumb. They are not child.
They will come back tomorrow.
How do I change the
Since I have heard the matter, I will forget.
I know the court is sympathetic. That's one issue.
No, it's not a question of sympathy. That's a question of consideration of your own notification dated 29 September 2022, Mr. Shannath.
Kindly do not forget, I am bound by the notification.
Yes.
And if the notification of 29 September, SLP is...
Allow your senior learned friend to argue. Don't
now 29, notification, therefore notification followed only NCT. NCT notification is questioned before the Supreme Court. Even the Supreme Court said that everything will abide by our
Supreme Court has said in case of DLED, from NIOS is permissible subject to two conditions.
That's my lord, permissible who has filled the form like this.
Yes.
But he had filled the form like BEd.
As per your notification.
My lord, subject to the result of the SLP. Why, matlab, deal with that? I request your lordships. What would be the result of the SLP then? Then your lordships passes every order subject to the result. Compliance is subject to
Let
the
him pass an interim order permitting the petitioners to switch over subject to result, as it has been done in case of Onnesha.
Well, kindly give me a day's time. Your lordship
Come back tomorrow.
কি বললো ওখানে?
ওখানে একদম
Mr. Sharnal, come back tomorrow since I have heard both of
No,
you.
no, certainly. Your lordship.
Substantive.
No, sir.
Apply your mind so far Onnesha is concerned and come back.
Great.
Issue. Matter is heard in presence of the learned advocates. কালকে কি position? Yes. কালকে কি পজিশন দেখো তো, কালকে আমার মনে হয় সুবিধেই হবে। নেক্সট হাফে নেক্সট উইকে 24 তারিখ 17 তারিখ অনওয়ার্ড বেশ কিছু মামলা ফিক্স আছে। হ্যাঁ, ভালো হবে। Matter is heard in presence of the learned advocate who is for the state. Matter is heard in presence of the learned advocates representing the petitioners and West Bengal Board of Primary Education. Stop. After hearing progress to certain length, Mr. Sharnal, learned senior advocate representing West Bengal Board of Primary Education has prayed for days accommodation. Stop. List the matter under the same heading for further consideration tomorrow, 13th November 2025. একটা লাইন ওই কোর্ট ফি ও ডিপোজিট করেছে, the document in support of depositing deficit court fee is taken on record. একুশে দিয়ে দেবে, 22 না?
Item number 2.
My lord, item number 2, I beg to appear on behalf of the petitioner. Yesterday, my lord, I sought your lordship's, my lord, kind leave to, my lord, allow me to assist virtually. Now, my lord,
Yes.
the fact remains is there are two petitioners before your lordship, and
Yes.
two petitioners, my lord, they participated in the selection
You are
process
appearing for
my
the
lord,
Union of India. Yes, Mr.
yes,
Sharnal,
my lord,
yes.
they appeared in the selection process for the constable.
GD.
And my lord,
Constable GD.
Yes, my
In
lord. I'm
CAPS.
grateful, my lord.
In CAPS.
Yes, my lord. So what happened is, my lord, there are one is that physical measurement test where both of them were declared, my lord, unqualified because they are not 170 centimeters. This is an admitted position. Subsequently, my lord, there is an
Where is the
provision
physical
for
measurement? Just a minute. I have marked it. Just a minute. 168.9.
yes. So, my lord, the second, my lord, there is a provision on
And another is 170.
yes. So, my lord, they
170 is the prescribed measurement.
no, my lord is for my lord, those are of the earlier round. I will come to that later. I will come to that later.
Yes.
The fact remains is in this qualification that is, my lord, being conducted in 2025, both of them were declared unqualified. And my lord, there is a provisions for making an appeal in terms of the, my lord, notification published. In terms of that notification, on the same date, they made an appeal, and in the appeal also, the appellate authority declared them unfit. Now, my lord, these are undisputed facts. My lord, what happens is the rule says that there is no further departmental remedy available to the petitioner.
Yes.
Twice measurement is done, you are unqualified, you go. My lord, there is no other departmental procedure. So, my lord, these are the admitted position. Now, my lord, what I beseech your lordship to look into, my lord, what has been going in my mind, what your lordship has taken into consideration.
Now,
that is
how
the
you have been disqualified?
Because my height was below
Measurement is 170.
169.
That was taken on 6th May 2025.
That is 169, my lord.
No, page 27. Mrinmoy Mondol.
2021 স্যার।
Hmm?
27 2021
These are previous years. They are
My lord, these are
25 is
25 years.
previous.
Yes. These are previous
There
years.
is a stamp and signature at the end of page 20, at the bottom of page 27. 6th
That
May
is, my lord,
2023.
23.
No, no, this is
My lord, that is 23. That is not 25.
Where from you are getting the date?
Anare bhai.
My lord, in the second page, your lordship is looking into page 27. Kindly,
Yes,
my
yes.
lord, turns up to page
Yes,
28.
23. It was an
Yes.
old, yes.
So this is my lord submission before your lordship. At the same authority holding me, I was rejected for some other ground in that selection process. But the same authority holding me, my lord, my height was 170 centimeters. My lord, in 2 years' time, the height cannot reduce. This is my respectful submission. So there has been a discrepancy in measurement of height because the height was conducted, the measurement of height was conducted by the same authority. If it was a different authority, my lord, I
But
would
even
not
it is
have raised this
in
question.
case of a single petitioner in 2023 was measured 170. Now it is 168.9. Now it is
Absolutely, my
168.9. Yes,
Absolutely, my lord. I'm
how this
grateful.
happened?
My lord,
How this discrepancy took place?
cannot explain, my lord.
In
Whether
in 2023, the height of the petitioner was measured as 170, and now it is 168.9.
he may have not exercised properly or something.
Now, for that height, the height will not change. Your weight may increase.
We do not know, my lord. These
Your weight may increase,
these scientific,
but your height will not change.
but the honorable division bench is of the opinion that this does not matter. Whatever happened last time, this is meant for this time. Measurement taken this time will only be considered. Specific. Kindly see this judgment. This is a Harun Mia. Same ground was taken in appeal, my lord. Kindly see page paragraph 6, page 3.
So, when petitioner was assessed 170 centimeter of height, then why petitioner did not get appointment?
My lord, he didn't qualify in the medical test. It follows the medical test where, my lord, several tests are there.
So, my lord, kindly see paragraph 6, my lord.
Paragraph 6.
Paragraph 6. Singular argument, my lord.
It says, my lords. Any of the plan, my lords. I just come to that, my lords. Because in my email, I have already told my lords. I just
Yes, then how?
Paragraph 10. Paragraph 10, my lord.
Paragraph 10.
Yes, my lord.
we come to page number P971, my lords. Page number 71, my lords. Dear Sujata Samantha, we refer to the communication students to address our college sharing to address. We would like to draw our attention towards the terms and conditions of the plans as mentioned below. Policy holder will surrender the policy after 5 years from the commencement of the policy. The fund value under the policy.
But there is a on identical point, Mr. Shannal, it is decided by the division bench.
Yes, my lord. If it is so, my lord, I cannot, my lord. Probably I was not aware. My learned senior friend will assist your lordship to that, my lord. I cannot say anything. If my case is squarely covered by the division bench judgment, there is no relief. That I have to admit. My lord, I cannot make any further submissions.
CAPF, it is in CAPF.
CAPF.
Central Armed Police Forces.
Recruitment
Matter is hard.
Paragraph 2.
In presence of the learned advocates representing the petitioners and
on the day. I will show that one.
Union of India. Grievance of the petitioner is method of measuring height. There are two petitioners,
Two petitioners.
same issue, deviation.
One has an
Matlab two
extra
petitioners,
disqualification.
same issues.
Same issue.
আচ্ছা, কি বললেন? Grievance of the petitioners measuring their height
Here.
for being appointed constable GD in Central Armed Police Forces within bracket for short CAPFS. Stop. It is submitted by the learned advocate representing the petition, or it is submitted on behalf of the petitioner. That the height measured by the authority in previous selection process does not tally with the height measured by the authority in the present selection process. And it is argued that there is no reason to disbelieve the previous measured height of the petitioners.
এই রাজা কি হবে? যদি হয়, strictly যদি follow করে।
Stop. It is also contended that there is no rationale in difference of heights measured by the authority for being appointed as constable. Sum and substance of the submission of the petitioners is that on giving credence to the previous heights measured or previous height measured by the authority, previous height of the petitioners measured by the authority in connection with different selection process, in connection with previous selection process, they should have been adjudged eligible in terms of measurement of height for being appointed as constable. Next paragraph. Such submission, the prayer made in this writ petition is opposed by the learned advocate representing Union of India based on judgment delivered by the Honorable Division Bench on an intra-court appeal being FMA 964/2025 within bracket Harun Mia versus Union of India and others. Stop. According to the respondents, similar issue was considered by the Honorable Division Bench in Harun Mia Supra, and the contention of the appellant was negated. Next paragraph. On perusal of judgment dated 11 September 2025 of the Honorable Division Bench in Harun Mia Supra, it appears that the issue involved in this writ petition is no more res integra. Stop. The fact which was considered by the Honorable Division Bench is that based on variation between the height measured on two different dates. Candidate was declared ineligible, and it was argued that ordinarily candidate cannot be shortened / reduced in a single year. In appeal, prayer was made on behalf of the appellant for measuring height by an independent body. Stop. Such issue was considered and it was finally observed in paragraph 10 of Harun Mia Supra. That measurement taken at the time of the current recruitment needs to be considered, not the earlier recruitment, not the measurement taken in earlier recruitment process. Stop. It was also recorded. According to the Honorable Division Bench, a plausible view was taken by the learned single judge in considering measurement of height taken by the authority in connection with subsequent selection process. Stop. Next paragraph. In view of the issue decided in Harun Mia Supra, this court finds there is no merit in this petition, and the same is dismissed. I think Xerox certificate copy next.
Yes.
Grateful to your lordship, my lord.
Affidavit of service, my lord.
Affidavit of service. Over the affidavit of service.
My lord. Item number 3. My lord, in this matter, my lord, kindly pardon me, my lord. I'm appearing virtually, my lord. My lord, I'm not well. Actually, for that reason, I could not attend and I have not obtained the instructions. My lord will kindly give this, not this Monday. I'll take the instructions, my lord, by Monday. But since I was not well, my lord, for that reason,
I have been declared fit by their medical opinion. Subsequently, I have been declared fit. Let interim.
At the time of call, Mr. Jha, learned advocate, appears. Mr. Jha, learned advocate, representing Union of India, on virtual mode, has prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands adjourned till Monday next, comma.
Can it be on 19th, my lord? Subject to my lord's opinions.
Hearing of this matter stands adjourned till 19th November 2025. 19th.
Grateful, my lord.
Item number 4, but item number 4, my lord, appear for the petitioner. Number
For the
in
High
this
Court,
matter, my lord, we have challenged the recommendation passed by the Internal Complaints Committee of this honorable court. Now, my lord, we have served upon the victim lady. My lord, the victim lady in her address which she had furnished before the, my lord, committee. Now, my lord, it has come back with the endorsement insufficient address. So, my lord, what I was beseeching, my lord, could the victim lady, my lord, she is also an employee of this honorable court, could she be served through the learned Registrar General? We shall serve a copy upon the learned Registrar General.
Lord, if your lordship directs, it can be, but Lord, before that,
Victim is the employee of,
Yes,
of
yes.
this court.
Lord, both the parties, they were employees of the High Court. Petitioner has now retired. Lord, only thing is, Lord, we are under the guidelines issued by the Supreme Court. Lord, even the documents where the signature and Lord name of the victim, Lord lady appears, that has to be Lord corrected because
But I
they
will
have
try to-
filed the petition along with annexures which
but containing
contains
the name and, my lord, the
That should be,
that should be deleted.
should not be disclosed.
That should
Yes.
not be disclosed.
So, Lord, kindly, Lord, ask him to.
But we shall do the correction.
Which respondent?
Lord,
My lord, she is the private respondent. We have not named her in the cost title.
Yes, in the cost title it is
no,
not.
no, cost title it's not there. But Lord,
Body of the
all the
petition.
body of the petition and Lord the annexures, where her complaints and all that is there, the signatures and the name should be removed.
There is a direction of the Supreme Court.
But so far as I know, my lord, it only
How many
applies to
occasions?
offences under the
If
POCSO
in
Act
various
and-
places this has occurred,
and
this has happened
376.
in the body of the petition, then it's better to withdraw and file afresh.
If she is not
No, we can
named in
only
the
ma-
cost title, that their name
It
can.
doesn't make any sense.
Yes.
In the cost title, it is she is not named.
Now we can, my lord, what we can do is in the body of the petition, my lord, we can mark it by a black pen, her name wherever it is disclosed. And my lord, the original documents we
No,
can.
no, it has already been circulated. It has been served upon the parties.
The party is the Honorable High Court and, my lord, the victim lady.
Withdraw it, file afresh on the subsumed cause of action.
My lord, may I say this? My lord, in criminal practice, my lord, what we generally do is, my lord, we, with the black pen, my lord, we delete the names and the papers in which we have deleted.
But
we put
already
in
it
a
is
sealed-
filed. You have
But this is
sent,
not in the server.
you have sent it for service, and the entire writ petition will be uploaded in the server.
So, my lord, apart from the state of West Bengal, my lord, nothing is done. Here, state of West Bengal is not a party. It is not in the Sarthak. But we can delete it and put the deleted pages, my lord, fresh pages in a sealed envelope. That is what we normally do in criminal practice. But that can be done.
But after effecting service of the writ petition upon the High Court, what is the scope to correct the relevant part of the writ petition? Parts of
But
the
if your
writ
lordship
petition.
grants leave, my lord, we can do.
How I can grant leave?
But
It has
to
already been
delete the
served upon
names.
the parties. It has already been served upon the parties.
And my lord, so far as my learned senior is perhaps talking about the Nipun Saxena judgment, it only applies to offences.
No, no, there is an rule of our court. It has been amended.
Relating to sexual harassment against women, any petition, the victim's name can't be there, and also in the documents annexures, the name has to be removed.
There is a rule of our court.
I cannot, my lord, clarify the annexures, my lord, because my lord, it's a recommendation, my lord, passed by the honorable judges of
No,
this
no,
honorable court.
that recommendation
My lord,
part I'm
can
not
we
saying.
touch it?
No, no,
But the
recommendation
body of
part.
the petition.
But the recommendation, my lord, the evidence, my lord, that is also signed by the honorable judges. My lord, whether, my lord,
No, no,
it can be
evidence,
done.
the evidence নয়, the documents যেখানে
The evidence also contains her name. That is the problem.
In evidence, it is disclosed.
Yes.
evidence, Lord, she has given evidence. So whatever evidence is there, that can't be changed. I'm
The
not.
order of the Internal Complaints Committee, it is also disclosed.
There is no problem. Internal Complaints Committee has talked about the victim. There is no name disclosed, but in the process of inquiry, obviously, my lord, she has gone and given evidence. And then she has also produced other evidences where her name is there. Lord, I'm not talking about the evidence. Lord, that part can be kept in a sealed envelope in the court records, and your lordship can have a look at it. My learned friends have it because in a disciplinary proceedings, in a proceedings by ICC, he has got all the copies. But I'm saying in the court proceedings, whether, Lord, after all, she is an employee.
But so far as the writ petition is concerned, she is nowhere named. Only in the
In the
annexes.
body of the petition, you have disclosed it.
No.
Name of
Victim.
Petition,
name of the victim has been.
no. In the
Only in
court-
the annexures.
Only in
Lord,
the annexures.
annexures.
It is only in the annexures.
But I am suggesting, Lord, the annexures, Lord, if my learned friend withdraws and files afresh, the annexures which contain
Yes, these are to be in the seal cover.
in a seal cover, he can produce it.
But alternatively, my lord, what we can do is, my lord, wherever our name is disclosed in the annexures, we can mark her name with a black pen. Same document, we can put it in a sealed cover.
Issue. No, sorry. The order of the internal complaints committee is under challenge.
Yes.
Recommendation.
The recommendation, in fact,
recommendation of the yes. In the writ petition, order of the internal complaints committee within bracket ICC is questioned, involving a female employee of High Court Calcutta. Stop. Though such employee has not been named in the cost title of the writ petition, comma, being respondent number 4, but there are annexures where name of the female employee is disclosed, which is contrary to the rule of High Court, relevant rule of High Court Calcutta. Stop. At the time of stop. The writ petition ought to have been prepared with greater caution in order to ensure that name and particulars of victim lady should not be disclosed. Stop. As the present writ petition contains defects by disclosing relevant documents where names and particulars of victim lady are disclosed. Leave is granted to the petitioner to withdraw the writ petition. Accordingly, the writ petition stands dismissed as withdrawn, with leave to file to file the writ petition on the self-same cause of action, strictly in terms of the relevant rules of the High Court at Calcutta, in order to ensure that name and particulars of victim lady should not be disclosed. Much of writ petition parties to act on the server copy.
One more prayer, my lord. The particular residential address of the victim lady, my lord, could my learned friend, my lord, disclose it to us, that if we file afresh, we can send it to her?
Lord, she is an
No, it is not required, Mr. Court. Please supply the copy of the present address of the lady.
In fact, she is an employee here.
Yes, that's
she can be served to the registrar. There is no difficulty. To the registrar general, she can be served. There is no difficulty.
There is no need to
nothing.
pass any order.
Absolutely.
To that extent.
And I don't know whether the administration would like to disclose her address if she has changed her address. It is better to serve through the registrar general.
Take steps. এমনি সার্ভিসটা তো হয়নি এখনো কমপ্লিট।
Item number 5.
Your Lordship, appear for the petitioner.
I beg to appear for 3 to 7.
Lordship, may I be permitted to file the affidavit of service, Your Lordship? On that day, the track report was not available. Today, I have obtained the same, Your Lordship. It has been served except for one respondent. And Lordship, on the last occasion, the
3 to 7 I am appearing.
Lordship,
3 to 7.
and they had prayed for a service of a copy. I have already served on Monday.
We have received it.
Who is representing Union of India?
I am for that. Respond number 1.
Lordship,
Yes.
Lordship. Lordship, straight away, I'll come to page 62 first.
Yes, yes.
Lordship. Lordship, herein the petitioners were engaged to work as dock pilots, but their initial engagement in the year 2012-2014 was on ad hoc basis. Now, while recruiting them on ad hoc basis, Your Lordship, the appointment letter which was given, Your Lordship, the initial entry to the post, Your Lordship, was following all the formalities which were required, and they had undergone a training. Lordship, thereafter, they are issued the license which are issued to the regular dock pilots, which is appearing at page 62.
Page
62. This license is issued to the regular dock pilots.
Dock pilot. Now this is the license, page 62.
Page 62, it is in respect of 3 of the petitioners. So this is page 62, 65 and 69. They have the similar license. Your Lordship, now this is the issuing authority.
What is your grievance?
Lordship, my grievance is that I'm praying for a regularization. It is not that I'm praying it today. It is the similar nature of work which has pleaded in paragraph 37, 39. Lordship, the vacancies were existing in the year 2012 to 2024 till date. Lordship, instead of regularizing, Lordship, the regularization representation I have made, which is at page 96.
You were granted license.
Granted license.
To function as dock pilot.
To function as dock pilot only.
How does it confer right upon you to pray for regularization?
Lordship.
Based on such license.
Lordship, not based on such license. Your Lordship, I am praying for the equal work with regard to the regular dock pilots. Now, today, Your Lordship, we are working there since 2012-20.
You are the licensed dock pilot.
I am the licensed dock pilot. Only to my name and ad hoc is attached. Your Lordship, now they have come up with the recruitment notification, which is at page 109. Lordship kindly takes that.
109.
Page 109.
Qualitative difference, qualitative difference.
Page 109, P19.
Yes.
It is the recruitment advertisement dated 24th September 2025. Now it is direct recruitment for apprentice dock pilot under Marine Operation Division, Holdia Dock Complex, SMPA. Lordship, I'm only concerned with Holdia Dock Complex. Now, Lordship, herein they have advertised for 3 posts, one for the OBCs, one for the EWS, and the other is for the UR. Now, Lordship,
so far there are 3 petitioners.
Lordship, we are 3 petitioners.
3 petitioners, they belong to which category?
Lordship, they belong to the general category, Lordship.
So how they can be...
Lordship, I'm not on that. I won't be participating in an advertisement, Your Lordship, because in the year 2012, I had come for the work, Your Lordship. There was ample opportunity for them to publish such advertisement at that relevant point of time where I could have participated at that point of time. Now I have spent 10 years of service, Your Lordship. I am before Your Lordship on the principles of Uma Devi, and recently I am covered under the recent judgment of Jaggo versus Union of India. Lordship, with regard to the similar nature of work, I am entitled to the similar pay. Today, I have not been given that also, Your Lordship. Now, Your Lordship, coming to the rules, where I'll later on place the rules. The rules are very categorical. If there is an urgency which is arising at that point of time, and on ad hoc basis, if one is taken, that ad hoc arrangement can continue at best for another of 6 months. That is a 1 year. And it is the deciding authority is the chairman and the
This is the only letter which comes in your aid, page 62, regarding your regarding the permission or license to function as doctor.
Lordship, my engagement starts from page 56. It is a regular appointment, Your Lordship.
Regular appointment?
Regular. Lordship, regular on ad hoc basis. Today they are up to that we will remove the ad hoc. We will be going for recruitment to the regular post in the sense. Your Lordship, my intention was using the word as regular in the sense, Your Lordship, similar work. Without a dock pilot, today a ship cannot enter the port, neither it can leave the port. Lordship, may kindly allows me to place page 56.
Associated, not the job of dog pilot.
Your Lordship is at page 56.
Yes, just a minute.
Lordship, may kindly sees contract engagement.
Just a minute, just a minute.
What is October?
So initial engagement was for a period of 3 years.
3 years. Now, Your
Thereafter,
Lordship,
what happened?
page 59. Renewed. Page 59. This is only with regard to the petitioner number 1 I am placing, Your Lordship. 2 and 3 have similar engagement letters, and their engagement is extended till 31st March 2028.
59.
Page 59. Page 59, the first paragraph, directed to offer you contractual engagement as berthing pilot. Your Lordship, I'll come to this definition. From 1st April 2025, subclause 1, your engagement will be for a period up to 31st March 2028.
Again for a period of 3 years.
The Lordship, from here, it is concluded that their nature of job is inevitable. Lordship, to the best of my knowledge, without a dock pilot.
No, but in between page 56 and page 59,
Lordship,
you were initially engaged on contractual basis. Video letter dated 23rd February 2012 for a period of 3 years.
Lordship.
Then this 3 years period expired in 2015.
Lordship, it continued.
Now thereafter, after expiry of first 3 years period, what happened?
Lordship, there was a continuation. There was
No separate engagement letter.
separate engagement letter was given. There is a continuation. I have not
In
annexed all of it.
2015, whether any engagement letter was issued.
Lordship,
Where is that?
Lordship, that is, I have not annexed. Lordship, it is there with us. I have not annexed, your Lordship. It will be, the petition would have been in bulk, your Lordship. That's why I have not annexed it, Lordship. Each and every occasion, the moment it was expiring, immediately another was issued, because without a dock pilot, even for one day, the maneuvering of the ships in the dock is not possible. For that, they need a licensed dock pilot. Now, Lordship, what is there, Lordship?
But now you are seeking regularization.
Lordship.
At the same time, you have submitted in reference to page 109, that is the advertisement or the initiation of selection process. You have not participated.
I have not participated.
So now that selection process has given effect to.
Lordship, no, it has not been given.
It is complete.
No, it has not been completed. Lordship,
Why you have not applied?
Lordship, today I cannot apply, your Lordship. I could have applied in the year 2012, 2020.
No, 24th September, pursuant to the recruitment notification dated 24th September 2025, why you did not apply?
Lordship, today if I go and apply, your Lordship, at the very first, there is for the UR category only one post. Only one, your Lordship. Today now,
The person who belongs to your category could have applied.
Lordship, the difficulty is that, your Lordship. Lordship, today, if I may give this example. Today, I have given the examination of law. Lordship, after I am working for 10, 12 years. Lordship, thereafter, again, if I am told to participate in such examination, which I have given in last 12 years back, your Lordship.
What is the right of your
Lordship, the right arises
in
out of
consideration of your contractual engagement,
Lordship.
as it emanates from page 56, where is your right to get to be regularized
Lordship.
in violation of Article 14 and 16?
Lordship, kindly allows me to
Because it is a
place-
public employment.
Lordship, the public employment, your Lordship. Herein, we are relying on the judgments of Uma Devi and the recent judgment.
In
which has-
Uma Devi, it has been spelled out that if any scheme comes up, there is no scheme.
Lordship, there is no scheme, your Lordship.
So therefore, how Uma Devi will
Lordship,
go against you?
Not scheme, your Lordship. Here it is, we are praying, your Lordship, kindly comes to the judgment of the present judgment, your Lordship. Kindly allows me to place this. Lordship, prior to that, your Lordship,
Which paragraph you are relying upon?
Lordship, in the writ petition, page 23, paragraph 37.
No, the judgment, which paragraph
Lordship,
you
I'll
are
come to
relying
the
upon?
judgment, your Lordship. I'll come to the judgment, your Lordship.
Please come to the judgment, which paragraph you are relying upon?
You sent me, no? Okay.
Uma Devi is squarely against you in absence of any scheme. And there is no such scheme. You have not made out a case. So for this judgment is concerned, which paragraph you are relying upon?
The last paragraph I'll rely, paragraph 27. Lordship, kindly sees. In
Just-
light of
Just
Lordship.
Dominated. Judgment.
Lordship, now here is
Just a minute.
So my education qualification was required because we were all sweepers and all. कोर्सेज से अगर एजुकेशन क्वालिफिकेशन ही नहीं चाहिए जॉब के लिए तो हाउ डू आई डिस्टिंग्विश एज ऑफ टर्मिनेटेड हाँ वो तो नहीं दिस इज एब्सोल्युटली सैंक्शंस आवाज इज नॉट अगेंस्ट सैंक्शन वेयर आर यू गेटिंग इट सैंक्शन कोर्स
This is a case of abrupt termination of service after dismissal of original application by the
Lordship, on the facts.
So the fact situation is completely different.
Lordship, now coming to the last paragraph, paragraph
Here
27.
your service is nobody is disturbing your service.
Lordship,
Now that notification has been issued for filling up 3 posts, now you are claiming regularization without applying or without offering your candidature pursuant to such notification.
Lordship, in that event, your Lordship, may I put this question to myself? Can all of us today, at this age, can we apply for the same? And what prevented them when the vacancy arose in the year 2012, 2014 to have advertised
Is it your
the same?
case that you are overaged?
Lordship, I have attained certain age.
Have you made out a case that it is a case of overage and there is no scope?
Lordship, no. There is no scope, I cannot say. Lordship, now coming to the paragraph 27. Paragraph 27 of this judgment.
Paragraph 27 has to be read in
Lordship, in the entirety. Lordship,
Yes.
Lordship, Lordship,
Not in isolated manner. I have read paragraph 27, Mr. Ghosh.
Lordship, what is my case is that, your Lordship, I am recruited. The only difficulty was that at that point of time, there was a requirement. What is the requirement? What is paragraph 27 speaking of? regards to the role of integral to the government organization, not only contravenes such and such
Bandyopadhyay, why
by
you are not
ensuring
considering them?
fair employment.
Blood,
Lordship, there is one more submission. Lordship.
why we are not considering them?
Lord, the petitioners, well, first of all, Lord, I bow down to what fell from your lordship. Lord, the petitioners are not being disturbed today because their
Yes.
contracts are still there till 2028. They have always been governed by this contractual relationship.
Still they are functioning
And-
as pilot.
Dock pilots.
Dock pilot, as dock
Master,
pilot.
I'll clarify this. situation.
Lordship, this is what I was
Lord-
trying to clarify. This
Yes.
Started by saying that they are dock pilots. Maybe in 2012, 2014, the contractual employment was with regard to a dock pilot. But
Associated.
But now kindly take the renewal, the fresh contract, which is at page 59. That is of the petitioner number 1. So I'll just stand corrected. It is not a renewal, it is a fresh contract.
It's berthing pilot.
It's a berthing pilot. Then kindly take petitioner number 2 at page 82.
It's a jugglery of
No,
Lordship,
it's not.
absolutely
I'll
done.
tell you, Lordship, why.
There is in the entire rules.
One by one.
Lordship, in
Submit
the-
one by one.
Lordship, this is what I was trying to place. In the entire rules, there is
completed, I'll take
concept.
submission. If not, then
Yes, yes, it's
And-
berthing pilot. That I have seen.
Berthing
I
pilot.
marked it. Yes.
82 is for the petitioner number 2. Your Lordship will kindly mark. And 85 is for the petitioner number 3. Now, my lord, when these persons were given the contractual employment, there was no regular mode of recruitment at all. As far as the petitioner number 2 and 3 is concerned, there was only a interview. And as far as petitioner number 1 is concerned, that also was not there. So, my lord, they have not come in by way of any regular mode of recruitment. Number 1. Number 2, my lord, these persons, your lordship will kindly see this perennial nature of work, my lord, which is sought to be argued. Kindly sees, my lord, the first contract at page 56 of the petition number 1.
Yes.
My lord, it is for a period of 3 years. The lordship has seen from February 2012, meaning February 2015. Now, my lord, the fresh contract comes at page 72. Your lordship will kindly see.
Yes.
My lord, it comes in March 2015. Not in February 2015. Therefore, the continuity which they seek to canvass is not there at all. Number 3, my lord, if your lordship sees the advertisement today, and it takes 109. There is the advertisement which is under challenge, if your lordship.
Yes.
Kindly take the right hand side of the first box.
Yes.
Essential, found essential.
Educational qualification, other qualifications. Yes.
Second mate, FG certificate or BSc nautical science with 60% marks. Well, this is the issue. The issue is not with regard to age alone. This qualification was not there in 2012, 2014, and they have also not pleaded so anywhere in the writ petition. That the
So is it your
qualification,
case that this qualification is not possessed by the petitioners?
60% was not a requirement at all. And your lordship will not find in the entire writ petition 2 pleadings, important pleadings for them. Number 1, that I am equally educationally qualified as the post that you have advertised for. Number 1. Number 2, your lordship will not find a single word in the entire writ petition saying that they have come in by way of a regular mode of recruitment. Unless they plead and prove that they came in by way of a regular mode of recruitment, the question of, my lord, removing the irregularity and regularizing them will not arise. But I have meticulously, I'll invite my learned friend to show those pleadings.
Paragraph 26.
Second one.
Then file your affidavits.
Paragraph
If you
26.
do not have the qualification in terms of
Lordship,
the...
I have higher qualification.
Yes, sir.
They should have pleaded
Lordship,
that.
paragraph
They should
26.
have pleaded that.
Lordship, paragraph. I've pleaded.
You have the qualification.
Yes, I have higher qualification. Paragraph 26.
Today,
Lordship,
the
kindly takes paragraph 26 once.
entire case is being set up.
Perhaps the Port Trust, the learned counsel has not gone through the paragraph. Paragraph 26 will be answering the said query.
There is no document on record. There is
Paragraph 26,
nothing on
I'm
record.
higher qualified. BSc Nautical Science degree.
Yes, 60% to wait. No one will.
No. Absolutely.
It is crafty
And
drafting where the percentage is
Lordship,
missed out.
now their use of words cannot be at
Where you have stated that you have 60%.
paragraph
than
26.
File a supplementary affidavit that you have
Lordship,
60%.
Lordship, and with regard to your Lordship, with
No,
regard
why you have not stated that you have 60% marks in BSc Nautical Science?
Lordship, that I can immediately take the instruction. Immediately.
Instruction is instruction not there.
Immediately, your Lordship. I will not say that I am.
It is not sufficient, Mr. Ms. Ghosh. Paragraph 26 is not sufficient.
Lordship,
It
in
is,
that
it is-
event,
it is-
your Lordship.
It is pleaded,
Lordship.
it is averred that as that of a BSc Nautical Science
Nautical
degree,
Science
thus
degree.
they were, yes, you had BSc Nautical Science degree,
Yes, your
but
Lordship.
with 60% marks.
I'll
Wait.
encourage
Kindly
it
mark
in
the
2
paragraph.
minutes.
They are overqualified
minutes.
in comparison to the erstwhile employee. Can you see the last sentence?
That I've seen.
Lordship,
Of
now
future.
this is now future. I cannot predict the future. 2020, 12, the
And
qualification
one
I
more-
was
one-
obtaining,
one
I
more
cannot
point.
Keep
imagine
your
in
energy
2024.
intact for filing affidavits. Yes.
Lordship, in that event, your Lordship, may I only pray, your Lordship, this recruitment notification
Yeah.
cannot be given effect to right now.
They are till 2028.
Lordship,
They are
the
till
recruitment
2028.
notification, your Lordship, very tactfully.
Affidavit of service filed on behalf of the petitioner
Sir,
sister.
qualification এটা
Next
requirement
paragraph.
যে আছে এটা তুমি প্লিড করনি কেন
Petitioners
you are higher qualified ও higher
were
qualified
initially
higher
appointed
qualified than earlier one ঠিক আছে
on
আজকে যে
contractual basis
60% in BSc nautical লাগবে সেটা তুমি কোথাও লেখনি বলবে তুমি
as dock pilot
এফিডেভিট ডিরেকশন দিচ্ছি
in Holdia Dock Complex, Kolkata Port Trust.
contractual
Dock pilot, huh?
No, I mean, let
Holdia
them
Dock
to the-
Complex, Kolkata Port Trust. And it is contended that
জাজমেন্ট দেখিয়েছে চাকগো
till date
এডুকেশন কোয়ালিফিকেশনটাই ছিল না
petitioners are functioning
sweeper
as
ছিল।
dock pilot.
ক্লিনিং সুইপিং ডাস্টিং এন্ড গার্ডেনিং ছিল এখানে
Attention
চার্ট
of
করে
this
দিয়েছে
court has
এভরিওয়ান
been
গট
drawn
রিলেটেড বলে যেখানে এডুকেশন কোয়ালিফিকেশনই লাগবে না
to
সেখানে তুমি
an advertisement dated
differentiation টা
24th
করতে
September 2025
then they went on to say
for filling up the post of
ওখানে হয় না সাথে কমপ্লিট আঠারোতে যাওনি
no, I don't think for filling up three posts of apprentice dock pilots,
স্যার আছে না কি বলছে
and it is submitted that ignoring the presence of petitioners as dock pilots, such notification, such advertisement, presence of dock pilot as dock pilots, recruitment proceedings ought not to have been initiated for appointment of other candidates on substantive basis. Stop. Prayer is made in this writ petition for issuance of mandamus in order to regularize petitioners as dock pilot in Haldia Dock Complex. Next paragraph, Mr. Dotto, you are appearing in this matter.
I mean, let me.
Mr. Kishore Dotto, learned senior advocate, appears on behalf of Haldia Dock Complex and has opposed this writ petition. Based on R3 to R7. R3 to R7. This one is 3 to 6.
The Kolkata Port Trust.
Port Trust.
Port Trust along with Holdia.
He sentenced a ball. No. Learned senior advocate is representing respondent numbers 3,
7
to 7, and it is and prayer of the and has opposed the prayer of the petition. Stop. A prayer of the petitioner based on initial engagement letter dated initial engagement letter issued in favor of the petition in favor of the petitioners. Stop. It is submitted that by no stretch of imagination it can be construed and it can be construed that a right is conferred upon the petitioners to claim regularization as petitioners were engaged on contractual basis for a period of 3 years and the term of contract and the term of service contract were subsequently renewed from time to time. Stop. It is also
Lordship, these were all throughout renewed.
stop. It is stop. It is also it is also contained. It is also submitted in reference to advertisement dated 24th September 2025 that requisite qualification prescribed for submitting application against three posts of apprentice dog pilots is BSc Nautical Science with 60% marks, and there is no averment made in the writ petition that petitioners having educational qualification of BSc Nautical Science with 60% marks. Stop. According to the respondents, perhaps petitioners do not possess the requisite qualification in terms of said advertisement dated 24th September 2025. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the issue involved in this writ petition, court finds the issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Petitioner shall be at leave to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Lordship, in the meantime, your Lordship, this advertisement may not be proceeded with, your Lordship. Lordship, let it be decided by this honorable court. Let it be decided, your Lordship.
Next paragraph. Appointments, if made in terms of the advertisement dated 24th September 2025, shall abide by the result of the writ.
Grateful, my Lordship. I have just taken the instruction. They have above 60%.
Yes, Mr. Doctor. New fresh contract.
No, Lordship. Lordship, these were all renewal. Lordship, every time there was a renewal, your Lordship.
The 3 months subsequently service contracts were renewed periodically. যা কি বললে ওটা দেখো তো। No, and petitioners were subsequently engaged by fresh contracts.
Lordship, this Lordship, and they have above 60%. I've just taken the instruction. Grateful, man.
Yes, call the
Item number
next
6.
matter. 6 হবে না, এটা হয়ে গেল 5.
Please, Your Lordship, I'm appearing on behalf of two petitioners. They were lecturers at Arambagh Government
Other
Polytechnic.
side. Other side.
We have served 7 respondents. Your Lordship served each
But
of them.
nobody is appearing.
This is the first time the matter is being heard.
New petition, nobody is appearing. Who are the respondents?
The respondents are, there is a
Have you
fact-
served upon the government pleader?
Yes, all of them have been served. There is a fact-finding committee against which we have a grievance, and
Date. You are also representing three. And who is, have you served upon respond number 4?
yes,
Private
we have
respondent.
served, we have served. We have
When it
served
was served?
everyone. 7-11. All of them.
Before my learned staff, may I take the maintainability point? This is a
Yes, if you-
maintainability point, my lord. It's absolutely government employee, my lord. They should prepare an application before the tribunal, not before this court.
Just a minute. Arup Kumar Rai, 916-5916. Just a minute. 5916. 565-916. 596. 559. Yes, served. 4th November, sir. Yes,
that's it.
Yes.
May I proceed?
Yes. He is taking the preliminary point of maintainability.
My point is that there has been a breach of fundamental rights, and I am entitled.
You are working where?
I was a lecturer at Arambagh Government Polytechnic. Then I was transferred. I am not challenging the transfer. I am challenging the fact that I was transferred on administrative reasons, and a fact-finding committee was instituted to find what was wrong with what the reasoning behind the transfer was to be uncovered by the fact-finding
It
committee.
relates to service matter.
Yes, but now
How
I
writ
was
petition is
I was
maintainable
shaft-
if you are holding a civil post? How this is maintainable?
This is a government college, Your Lordship. This is a government college.
It's a fully government college. Suppose
Yes.
you are working in Presidency College.
Yes.
So whether writ petition is maintainable relating to
Your
service of a
Lordship,
professor of that college?
My argument is I was denied a right to fair hearing because the fact-finding committee is
relates to your service matter.
Is a quasi-judicial body. And
No, sorry. Certainly not.
Your Lordship, the fact-finding committee that I'm questioning, I
It's
have
a fully government college.
Yes.
Appointment through Public Service Commission.
Lordship.
Yes.
And he was transferred in they
On
have been transferred
administrative
one in
grounds.
Kuch Bihar and one in Kalimpong. Although the transfer doesn't have any.
Why you
relation
have
with
filed
present-
here? Wasting your time.
Your Lordship, since I have been shafted out of the process which decides whether the transfer was meritorious or not, if I want to challenge the transfer before
Go
the
to the
tribunal,
tribunal and fight it out.
if I wanted to challenge the transfer, I would have gone to the tribunal. I am asking for an establishment of my right to fair hearing because all the information that is being supplied to me is supplied through my diligence. I have filed a plethora of RTI applications, and I have received information piecemeal. No one is giving me the evidence that is arrayed against me, the charges that are arrayed against me. I am perfectly fine working in another college. We will challenge the transfer separately in the forum.
Main agent come to prayer D, page 30. The respondents, their main agents and agents to provide the petitioners with all relevant documents
Yes.
and records relating to their transfer.
Yes.
With a transfer order number so and so issued by the Government of West Bengal Technical Education Training and Skill Development Department.
Yes.
It is not relating to your service.
Your Lordship, may I just make the point? If
I am asking you,
yes,
it is not relating to your service.
it is because I'm not challenging the transfer. What I'm challenging is that I intend to challenge the transfer before the tribunal. That is well settled. But to do that, I should have the documents which allowed the transfer to happen because I was transferred on administrative reasons. And this was done in the middle of the semester.
Fact-finding committee was constituted by whom?
The fact-finding
And regarding what?
The appointment, page 89, Your Lordship, the fact-finding committee was constituted by the Government of West Bengal Technical Education Training and Skill Development Department, Karigori Bhavan.
Regarding what?
Regarding the, now this is something that I have
So
to
regarding what I
clarify.
am asking?
Yes.
For what for fact-finding committee was constituted?
Chronologically, please bear with me. I was transferred on administrative reasons. Until today, I have no idea what reasons there were. All I wanted was to know what the reasons were, make my defense. The fact-finding committee, through my diligent application of several RTI
So
applications.
based on the exercise made by the fact-finding committee, your transfer was made?
No, this was done after the transfer was effected. Now, my prayer, my singular prayer is that I be allowed to participate in the fact-finding committee so that I know what reasons I have been transferred to. Right.
Here comes the issue.
Yes.
So it relates to transfer.
It relates to
It may be
transfer later.
punishment transfer. It may not be a punishment transfer, a regular transfer, but it relates to a service of the petitioner.
But if I am to challenge the transfer, Your Lordship, kindly, if I am to challenge the transfer, I need the documents. Your Lordship, if it is a quasi-judicial body, is it not beholden to the fundamental rights? I should be made a party to the
Affidavit of
proceedings.
service filed on behalf of the petitioner is taken on record. Stop. At the threshold, learned advocate representing the state respondents has raised the question of maintainability of this writ petition before this court. Stop.
Your Lordship, may I just say one thing?
Petitioners, in which post they are working?
Lecturers. Your Lordship, if I am
Petitioners
to
are
challenge
working
anything, Your
as
Lordship, I need the
lecturers
documents.
in
If I am
then
not,
the college has been made party.
yes, yes.
Yes.
Your Lordship, if I do not have the materials, where do I go? Even the tribunal will reject my case if I am not made party to the proceedings. All I am asking is they provide me with the documents and I am participating. That is not much of an ask, Your Lordship.
Where you are, he is working.
But he was working at Arambagh. Now they are
What is the post of lecturer? Where?
at one is at Kalimpong Government Polytechnic.
After transfer.
After transfer, one is Kalimpong.
Previously, where petitioners were working?
Arambagh.
Arambagh.
Hooghly.
Yes. Where?
Arambagh Government Polytechnic College.
Where from you are getting this?
Yes, my lord. Your lordship, kindly come to page.
P1 is transfer order. I have mentioned that. Page 36. When is the transfer order?
They have stated at.
Please wait, please. Do you have any instruction relating to the reason of transferring the petitioner?
My lord, I don't have, it's absolutely administrative reason, my lord. And fact-finding committee has been constituted only to inquire the for a preliminary inquiry on the basis of the allegation made by the other employees. That your lordship can find it at page 71. It's a preliminary inquiry. If
relating to transfer.
not
Fact-finding
relating to
committee, what was the reason for constituting fact-finding committee?
in respect of the allegations made against the petitioners by the other employees. The
And I
lordship
am
can-
not
lordship-
even being made party to that.
Lordship may find it out at page 71.
I
It's
did
the
not even know a
complete-
committee was instituted.
No relation with the transfer.
And the documents I have received are through my efforts, your lordship. They have not served me with anything.
এসো হ্যাঁ কি বলছেন? Petitioners were working as lecturers in Arambagh Government Polytechnic and were transferred. And petitioner number 1 was transferred to Kuch Bihar Government Polytechnic, whereas petitioner number 2.
Petitioner number 1, Kalimpong, and 2 is Kuchbihar.
Petitioner number 1 was transferred to Kalimpong Government Polytechnic, whereas petitioner number 2 was transferred to Kuch Bihar Government Polytechnic. Stop. Prayer is made in the writ petition for providing relevant documents and records relating to the transfer of the petitioners. Stop. However, it is submitted on behalf. It is submitted by the learned advocate representing the petitioners that the issue involved in this writ petition has no nexus with the service with the service of the petitioners as lecturers in government polytechnic, as prayer is made for supplying materials considered by the fact-finding committee. And it is, and according to the petitioners, writ petition in its present form is maintainable before the High Court. Stop. On going through the materials available on record and taking note of the complaint which is at page 71, it appears that complainants approached the principal in charge Arambagh Government Polytechnic against the petitioners, alleging misbehavior / misconduct in due discharge of the duty, in due discharge of their duty, alleging misconduct in due discharge of duty by the petitioners while functioning as lecturers of Arambagh Government Polytechnic. Stop. Next paragraph. Therefore, it appears the issue involved in this writ petition relates to service of the petitioners. Stop. As the petitioners are government employees, they ought to have government employees, they ought to have taken it. The government employees, at this stage, writ petition is not maintainable before this court in view of section 15 of the Administrative Tribunals Act 1985. Stop. Hence, the writ petition stands dismissed. However, this order shall not preclude the petitioners to approach West Bengal Administrative Tribunal on the self-same cause of action. Stop. Urgent Xerox certificate.
Your Lordship, on this point, may I just clarify something?
Please call the next matter. Yes, give your name.
Item number 7.
Respondents.
Hi, my candidature has been rejected on the ground of shortfall of height. My lord, there is a notification. In the notification, there is a clause 12.5.5. There is specific
clause
12.5.5, page 29. The relevant portion I have annexed. This is a female candidate. Its required height measurement is 157 centimeter.
Page 12.5.5.
Yes, page 29 of my rate application. It's a female candidate, as the height requirement is 157 centimeter.
Just a minute. It relates to appeal. It is relating to appeal.
Yes, I am coming to that point. My lord, kindly come to page 19 of my writ application. 19 of my writ application.
Page 19.
19. My lord, this is the PST board finding, and my height has been measured 156.3 centimeter. My lord, then
height, page 19, 55.3.
56.3.
Wait. Oh, height is 156.3.
156.3. That
Yes.
is the less than the required height.
That is?
That is the less of required height.
What is the required height?
Required height is the 157 centimeter.
Yes.
Shortfall is 0.6 centimeter.
Yes.
My lord, in the clause 12.5.5, I have a right to appeal against this order before the appellate authority through presiding officer. I have been driven out from the campus. I have not allowed to file. I have specifically avoided. My lord, what happened subsequently thereafter? On 15 September, I filed appeal through email to the respondent authority, and this point has been decided by the Honorable Division Bench of this Honorable Court that don't go for any technicality. Even if the appellant filed the appeal through email, subsequently thereafter you consider.
When you have preferred appeal through email?
Yes, page 22. Page 22.
15 September.
Yes, 15 September through email, I preferred appeal before the respondent authorities. That appeal has not.
So you are praying for disposal of this appeal?
Yes, my lord, on this point, my lord, this honorable.
Let it be disposed of. Few days back, I have directed in similar matter. Yes, when the appeal is preferred, let it be disposed of. I passed order in two consecutive matters. That since the alternative remedy is available, therefore, before coming to this court, you should have preferred an appeal. And even after expiry of some time, I permitted the petitioner to prefer an appeal, and there was a direction to dispose of the appeal by the appellate authority. Yes.
May I handle?
It's not required.
Lordship was dictated, my lord, that 3 days, within 3 days, the references should be made, and after that, a fortnight time is given.
No, but if by email this appeal is preferred, whether the appellate authority are in a position is in a position to dispose of this appeal, or I shall grant leave to the petitioner to prefer appeal by 7 days. That will be better.
But this order has been said that you make a representation within stipulated period, and
that is what I have passed. Similar order I have also
That's
passed.
why I have given this order, my lord. That will be better. Along with your lordship's order and the documents that I relied on.
It is Constable GD in CAPF.
CAP. Constable GT for the 2025. This is my appeal.
Affidavit of service filed on behalf of the petitioner is taken on record stock. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket for short CAPFs. If stop. Small is. It is contended on behalf of the petitioner that height of the petitioner was measured as 156.3, which is less than the requisite height for a female candidate, that is 157 centimeter, 156.32 centimeter, 157 centimeter. Based on measurement of height of the petitioner on 10 September 2025, petitioner was adjudged as ineligible. Stop. It is submitted that petitioner made an attempt to prefer an appeal on the self-same date, on the date of taking measurement of height of the petitioner, but she was not permitted, which prompted the petitioner to prefer appeal by email letter dated 15 September 2025. Attention of this court has also been drawn to the provision of appeal as contained in clause 12.5.5 of the provision of appeal as per clause 12.5.5 as contained
It's helpful with the notice. Notice, the previous notice.
in the notice uploaded or notice uploaded on the website of staff selection commission. Staff selection commission on 5th September 2024. On 5th September 2024. Stop. Learned advocates representing Union of India submits, since there is provision to prefer appeal, petitioner, if prefers appeal in offline mode, same shall be decided in accordance with law. Next paragraph, having considered the respective submissions made on behalf of the parties, leave is granted to the petitioner to prefer appeal by 3 days, by 3 days from date, or 7 days করে দাও, by 7 days from date before the appellate authority, if appeal is preferred within the aforesaid time.
Yeah, correct. The appellate authority now, the respondent number 5 is the nodal. For the appeal before the respondent number 5.
Director General Central Reserve Police Force.
The head of highest authority of the nodal agency.
It is not required to prefer appeal before the Staff Selection Commission.
Because this part is conducted by the nodal as per their and employment.
But 12.5.5 refers to appellate authority.
Yes, but in that notification, it has been mentioned that the PST, PET, and medical examination will be conducted by the nodal agency appointed by the Home Ministry of Home Affairs.
Not actually competent authority. It's a rounded competent authority. He may be the competent authority before. It's better.
Head of the nodal agency.
কাজ করো লাস্টে যে অ্যাপিল যেখানে বলছে না এই প্যারাগ্রাফটা পড়ো তো না তার আগে থেকে ওই 7 days যেখান থেকে বললাম না to make a representation to Director General Border Security who is respond number 4 to the Director General Central Reserve, to the Director General, Central Reserve Police Force within bracket CRPF, within bracket Recruitment Board, being response number 5, questioning measurement of height of the petitioner made by the authority on 10th September 2025 by 7 days from date. Stop. If representation is made before the respondent number 5 within the aforesaid time, said respondent shall decide the same in accordance with law by 4 weeks from the date of communication of this
Medical will be
over by fortnight from the date of communication of this order, and the decision to be communicated to the petitioner by 48 hours there. Next paragraph. The writ petition stands disposed of. Urgent Xerox certificate. Central Armed Police Force করে দাও তো, কারণ এখানে দেখছি এরা এইভাবে ও সিআরপিএফ সেন্ট্রাল রিজার্ভ পুলিশ ফোর্স, তাহলে ঠিক আছে। সিআরপিএফ নেক্সট
Item number 8.
No,
8, may I please, Your Lordship, I am for the petition. This is my affidavit of service. What happened? I have qualified all the hurdles. My lord, my name has been put in the waiting list due to, my lord, mismatch of biometric. My lord, my fingerprints. My lord, I have
Constable GD.
Constable GD recruitment year 2024. My lord, once they have asked me to appear before the
There is a case of mismatch.
mismatch of biometric.
Biometrics.
Fingerprints. Then, my lord, I have asked for again to give my fingerprints. I have already done. My lord, results was published in 13 December 2024. Today we are verge of end of the year. My lord, 1 year. My lord, after filing this REIT application, she again asked to give the biometric 14th October. My lord, before the CFSL Kolkata. My lord, I don't know what fate they have received, but
Central Forensic Science Laboratory.
yes, my lord, that is the my learned friend can
Actually, my lord, this
whether
matter, my lord,
So after the it was found that it is a case of biometric mismatch. Subsequently, you are not called for. You are not called. You are not asked to appear before the authority for biometrics.
My lord, my lord, twice they have she has given. Once prior to filing this REIT application, asked to appear before the court to give the fingerprints. She done. After filing this REIT application, and she again asked to give the biometric on 14th October 2025. She again given. My lord, if the biometric is not being matched with my fingerprints at the time of my biometric test, then the respondent authority is liable to pass an reason order that this thing has been happened and your candidature is been rejected on this ground. Then I have an opportunity to challenge that. But I am not going into that effect till now. But my learned friend can assure whether my biometric test has been done or not. If it is matched, then I am
the thing
entitled
is
to
this,
get
my
that
lord,
job.
my learned friend is asking employment under the BSF. BSF is not the party in this REIT application. So this is the difficulty, my lord. I could not, my lord, take the instruction. Though I have received this brief yesterday evening, and my learned friend has, my lord, served only to the ministry, not to all the respondents. Be that as it may, my lord, I can take instructions if, my lord, BSF.
BSF will not be
The
made party.
BSF is not the party, required
Yes.
party, because I am saying that what my learned friend is pointing out, well, this examination is conducting by the SSC, and the nodal agency was the CRPF 2024 examination. So BSF has no role, because in waiting list, the withheld list, there is no indication what category I have been recommended. The SSC is the only the recommending authority, recommended the name to the department, either BSF or CRPF and CISF. My lord, in the withheld list, there is no indication.
But he had to be. If you are if it is found that there is it is not a case of ultimately it is not a case of biometric mismatch. In that event, you will be appointed.
Yes, I appointed.
You will be
under the
appointed.
BSF.
Who will appoint you?
BSF.
Made recommendation, and the department will appointment.
BSF.
Then why BSF will not be made party?
Because the biometric test they are going to the nodal agency.
So you want up to the point of recommendation.
Yes. If the recommendation is not being done,
Mr. Ghosh, you tell me that why
Page 28.
why
if
it
you-
is necessary to
Page
add
20,
BSF as
I have to take instruction from the BSF.
I can.
No, but it is
You-
if the test is conducted by staff selection commission.
Commission, but sent from BSF. Sent from BSF. Now, my lord, ultimately, if it is found that his case is genuine,
But
then
who conducted this biometric test?
biometric test is to be conducted by, my lord, the forensic department, but sent by BSF. So I have to, my lord, take instruction from the BSF.
Who is to be forwarded?
BSF.
Which authority will forward it to CFSL
BSF.
for biometrics?
BSF. Kindly see page 28, my lord. Last paragraph. Ultimately, he has to be appointed in BSF. However, my lord, it is intimated that the such and such Durgapur has ascertained from your dossier that your biometric data was not mismatched at the time of recruitment. As such, as per direction given by the headquarter DG BSF, your case is under consideration, such and such.
What is CAPB?
This is the, my lord, the central, I don't know the full form, my lord. This Central Fingerprint Bureau.
But it is on based on the direction given by headquartered DGBSA.
BSA. And now
If it is a case, if there is positive result after fingerprint test or biometric test, then it is to be forwarded to DGBSA.
BSA.
Well, I shall meet him.
And he will be in difficulty, my lord, if it is found, my lord.
Is appearing.
He's correct.
Yes, yes.
He will be in difficulty. That's why, my lord.
So you will represent BSF also.
I will.
So no separate service is required.
So it's not necessary.
But I shall,
But my lord, I will.
being at liberty to add BSF. My lord, it is my
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In reference to remarks as contained in paragraph 28 of this writ petition, it is contended by the learned advocate representing Union of India that concerned authority of border security force within bracket BSF needs to be added as additional respondent. Stop. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cost title in course of this day.
Yes, yes.
To amend the cost title in course of of this writ petition in course of this day, and array concerned authority of BSF as additional respondent / respondents. Stop. However, service of notice upon additional respondents stands dispensed with, since Union of India is represented by learned advocate. Stop. List the matter under the same heading for further consideration. Now, next paragraph. Learned advocate representing Union of India is directed to obtain instruction from additional respondents by 7 days from date. Stop. List the matter under the same heading for further consideration on 19th November 2020.
Much grateful to us.
Ultimately, if it is found his case is genuine, he will be difficult.
Yes.
That's why I have pointed out.
My lord, I should have. It is my mistake, my lord. I should have.
Item number 9. We are all the respondents.
My lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, issue is very short. My lord, I have made an appeal through email. That is, my lord, may I just take your lordship to the case?
A few minutes back, I have disposed of one matter. Similar issue cropped up, and court directed that by 7 days he will prefer an appeal in offline mode before the concerned authority, and that will be decided by fortnight thereafter. Is it a case of height?
My lord, only one indulgence.
Is it a case of measurement of height?
Yes, absolutely.
Yes. Where is the relevant document containing
my
measured height?
My lord, only one thing, my lord.
Page 16.
Yes, page 16, my lord, 169.
169.3 is a male candidate.
Yes. So that is 170 is for the male candidate.
Yes.
And my lord, my representation through, that is not a representation, but my lord, an intimation to the authorities at page 18. Now, my lord, only one indulgence. I know my lord has passed an direction, but the fact remains is my learned senior friend can also assist your lordship on that point. Whether the appellate authority, my lord, if your lordship directs today, my lord, whether the appellate authority can take a call, because after the measurement is over.
No. In other matters, appellate authority is no more in existence. So who will decide the representation of the petitioner?
My lord, and that is the issue, my lord. If your lordship directs the competent
Director
authority.
General Central Reserve Police Force.
Director
General CRPF will decide it.
My lord.
Because appellate authority is not in existence.
I'm grateful to your lordship. I'm grateful to your lordship.
You make a representation within fortnight from date, within 7 days from date, and that will be decided in accordance with law by fortnight thereafter.
Yes, my lord has passed similar directions in other matters
This
also.
measurement was taken. It is not found from page 16.
I am so, my lord, it is very unfortunate that this has been an illegible copy that has been handed over.
Generally, date is mentioned in the measurement document,
Yes,
in the
but I
document
find
containing measurement of height.
the seal is illegible, and my lord, I
Then
think I should come back, my lord. I cannot make an submission until and
it is
unless
not
my
clear
learned.
than which date your height
Yes,
was measured.
my lord, there is no averment also.
The
I've
medical
just,
report was conducted, medical test was conducted October 2025.
but I need to give a specific date to your lordship. Because in my email, the date is there. That is 28th August. But
I think it is on 28th of August 2025.
yes,
That physical,
that
what
is in
is
page 18, my lord. If your lordship
physical
goes to
test
page
was
18,
conducted on 28 August.
that
Yes,
is in
let,
page 18.
let it be
If your
disposed
lordship,
of.
my lord, I'm grateful. I'm extremely grateful.
File your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner participated in the selection process for being appointed as Constable GD in CAPFS, in Central Armed Police Forces.
My lord.
In in Central Armed Police Forces within bracket CAPFS, close bracket. For short, CAPFS. However, on measuring height of the petitioner, it was found petitioner's height is 169.3 centimeter, which is less than requisite height, that is 170 centimeters. Stop. As per norms, it is submitted as per norms. There is a provision to prefer an appeal, and petitioner petitioner approached the concerned authority for consideration of his grievance via email letter dated 29th October 2025. Stop. Petitioner prays for consideration of his email letter dated 29th October 2025, whereby measurement of height of the petitioner was challenged. Stop. Next paragraph, Union of India is represented by learned advocate who submits that petitioner is required to prefer a representation to the Director General, Central Reserve Police Force within bracket CRPF, being response number 5, within a specified time for consideration of his for adjudication of his grievance relating to measurement of height. Next paragraph, having considered the respective submissions made on behalf of the parties, leave is granted to the petitioner to make a representation to the respondent number 5 by 7 days from date, questioning a measurement of height which was taken on 28 August 2025. Stop. If such representation is made within the aforesaid time, respondent number 5 shall decide the same in accordance with law by fortnight thereafter, and the decision to be communicated to the petitioner by 48 hours thereafter. Stop. Writ petition stands disposed of, urgent Xerox certificate copy.
Well, that is clause 12.5.5 to be
It
precise.
is not required because
My lord.
there is no appellate authority at present.
I'm
You make a
grateful.
representation questioning the measurement, that will be considered.
My lord, I'm grateful.
Item number 10.
Lordship, in this matter, Ms. Pona Roy Choudhury appearing in behalf of the State Fisheries Development Corporation, Lordship. She has engaged in court number 11. I am praying for short passover, Lordship.
Not today.
Good.
Item number 11.
I am appealing for the respect.
Your Lordship, kindly take it item number 13 first.
13 টাকে দাও তো ইন্ডিকেট করে দেবে এটা থাক সিমিলার ম্যাটার এটা এখানেই থাক 13 টাকা
Item number 13.
I am appealing for
13.
Yes.
In this case, my lord, pending criminal proceeding, my lord, departmental proceeding was started. The charge and allegation, both in the departmental proceeding and the criminal proceedings, are same and identical. The charge are grave in nature, complicated question of law is involved, and the prosecution witness, both the cases are same. Now, my lord, your lordship kindly come to the substantial question of law first. In this case, my lord, the charge sheet was issued on the basis of a preliminary inquiry report, which was conducted by the Inspector Railway Protection Force. But Inspector Railway Protection Force has no power and jurisdiction to conduct the preliminary inquiry when it is a public complaint against the misconduct of the petitioner. The lordship kindly come to 248.1.
Give me the book. Give me the statute.
248.1. Public complaint against the misconduct of the member of the force. Whenever a complaint against the misconduct of any member of the force is received from the members of the public, or where such complaint is received to a court wherein similar criminal proceeding against the member of the force has been instituted or otherwise, and controlling officer of such member of the force is of the opinion that allegations are verifiable or otherwise an inquiry is called for, he may proceed to inquire into himself into the complaint against a member of the force specified in column 1 of the table below, or depute any other official as specified in the corresponding entry in column 2 of the said table. Now your lordship kindly come to table. I am inspector. As Inspector, Assistant Security Commissioner, who is empowered of
Inspector or assistant? In case of inspector and assistant, yes. Who should be the inquiry officer as per table?
of and above the rank of Security Commissioner. But, my lord, in this case, the inspector has conducted the inquiry. He has no power and jurisdiction according to rule. My lord,
Just a minute. But there are certain conditions in 248.1. It says that whenever a complaint against the misconduct of any member of the force is received from the members of the public.
Public, member of the public.
Yes.
The complaint was received from the member of the public. Public made a complaint against me. That
Show me the complaint.
basically come to the statement of allegation.
There are two preconditions. One is complaint has to be from the member of public, or where such complaint is received through a court wherein civil or criminal proceedings against a member of the force have been instituted or otherwise.
Alternative, either public or court. So public made a complaint.
So show me the complaint.
Logically come to statement of allegation. Yes. 34. Imputation of allegation. Shri Shantanu Kumar Jakwa lost a complaint before the Central Bureau of Investigation Anti-Corruption Bureau against certain official of the Railway Protection Force. In his complaint, he stated that he is engaged in operating a saloon and a Dhaba railway land measuring approximately 22.3 square meters, for which he pays annual license fees to the railway. He further alleged that for the first 3 months, he has been selling beer to customers at his Dhaba with the assistance of his brother, Sri Shivaji Dhapur. During the period, he and his brother have been subjected to harassment by Head Constable Somu Prasad Singh and Inspector D.P. The complaint specifically accuses these officials of repeatedly demanding illegal gratification in connection with the operation.
Where is the charge sheet?
My lord, by second submission, as
Where is the charge sheet? Where is the charge sheet? Memorandum of charge, page 31.
31,
Just.
Lordship Alishi, while framing the charge and allegation, Lordship kindly come to serial number 1. Serial number 1. Sri Amaresh Chandra Sinha, ASC RPF Secretary is nominated as an info officer who will conduct the inquiry myself.
Where?
My lord, 31.
31.
Yes, 31.
Yes, based on.
Memorandum.
Yes, memorandum.
Then 1, serial number 1. Amaresh Chandra Sinha, ASC RPF Secretary, is nominated as info officer who will conduct the inquiry myself.
So it is, according to you, it is a case of complaint from public.
Public, that is first submission. Then, my lord, the second submission, the disciplinary authority, my lord, without giving me any opportunity to give reply to the charge and allegation, straightway proceed against me by my lord.
What is the present stage of discipline proceeding?
My lord, all the date of inquiry was fixed, but nothing was proceeded.
When it is fixed?
And
When it is fixed?
fixed on, my lord, you will also kindly see 16th October, 10:30.
Yes, 16th October, what happened?
My lord, nothing was happened. I appeared, I give my appearance.
So your submission is now twofold.
Twofold.
One is this, that this assistant this Amaresh Chandra Sinha, what is his designation?
Assistant Security Commissioner, ASC means Assistant Security.
Assistant Security Commissioner cannot function as security as inquiry officer. One who the security officer must be security commissioner of or above the rank of security commissioner. Either security commissioner or above security commissioner. And without granting you opportunity to respond to the charge sheet, inquiry proceeding was started.
And name of
Now in the memorandum of charge, now no time is stipulated to furnish reply. In the charge sheet, which is at page 31, no time is stipulated.
No. Nothing.
But generally in the charge sheet, it is stated that you give reply within certain time.
No, nothing. That is why my point is this, that Supreme Court held in the Vivekananda case that without giving any opportunity to give reply to the charge sheet, if you straightway proceeded against me by announcing the name of the incorruption, it reflects bias. Also, kindly see the judgment of the apex court.
Yes, what is your instruction? How, first of all, how this assistant security commissioner can function as inquiry officer, which appears to be contrary to rule 148.1, a 248.1.
That I have to take instruction, my lord. My lord, that I am not able to take instruction. And so far,
Yesterday you prayed for time to take instruction.
my lord, I shall take instruction, my lord.
And the second question is how second point is that without granting opportunity to give reply to the charge sheet, how inquiry proceeding has commenced.
My lord, how far he is correct, my lord, I have also have.
Well, take instruction, come back.
Yes,
Yes.
I shall take it.
Come back at 2. I will pass out.
Yes.
Mr. Mojumdar, come at 2.
My lord, may I be permitted to mention one court application, my lord?
Next Wednesday, under the heading court application.
Two matters, my lord. One court application, my lord. Another matter, this matter, there was a direction to file affidavit on the respondents. My lord, the time has expired on 7th of November. I was paying for extension, so the matter can be.
You have to file opposition.
My lord.
To be mentioned.
Well, I am appearing.
Sir, notice upon, you are appearing
Please for
for the petitioner?
petition.
Wednesday next week at 2 p.m.
My lord,
Continuing matter, item number 13 from appellate side.
before passing this order, my lord, I am humble submission, my lord. Kindly see, my lord, page 20.
Yes.
Entire
First answer the query based on points raised on behalf of the petitioner.
that's I'm coming, my lord.
That how this
My lord, and that I'm not going into the merit of the case, my lord.
assistant security commissioner can act as inquiry officer.
That's right. That's right. I'm not going into the merit of the case. I respectful submission before my lord. This court has no jurisdiction. Entire proceeding in the state of Cuttack, Odisha. Entire proceeding. Kindly see the FIR.
Where is Chakradharpur? It is in Odisha.
Entire proceeding. Chakradhar, Odisha. Anticipatory bail also obtained from Odisha.
Yes, Mr. Majumdar, that struck my mind. Then Chakradharpur, yes.
Page 24. Page 24, anticipatory bail.
Committee was framed by the Deputy Inspector General RPF, Southeastern Railway Garden. On the basis of the committee report, my suspension period was extended.
No, but a charge sheet was issued from Chakradharpur.
Charge sheet.
Odisha.
That I have seen.
I was placed under suspension first. That's kindly come to
page 21.
Order of suspension.
Please come to page 32.
Hello?
Please come to page 32. Senior Divisional Security Commissioner, Southeastern Railway, Chakradharpur.
Yes, that is true.
Yes.
That is true.
Yes.
But, my lord, the departmental proceeding was started on the basis of the suspension order. I am, my lord, before your lordship.
Inspector of RPF, Railway Protection Force, post Bimalgarh at DRC Chakradharpur under Southeastern Railway.
Yes, sir.
That is the description of your of the petitioner. Cost title.
My lord.
Cost title, come to the cost title.
Yes, cost title here, lordship, kindly come.
Yes. Description of the petitioner.
Lordship, kindly come. Cost title.
Yes.
Respondent number 3.
No. First description of the petitioner. Petitioner.
Yes, that may be.
Inspector RPF post Bimalgarh at DRC Chakradharpur under Southeastern Railway.
Railway, yes.
Yes. So where you are posted?
Southeastern Railway is the authority.
But where you are posted?
I am posted at
Bhimanagar.
RPF post Bimalgarh. Under
Bhimagarh.
Yes. Lordship, kindly you please allow me. Lordship, kindly come to P4, page 27. As communicated by DIG Chief Security Commissioner RPF Southeastern Railway, Garden Ridge Office, letter number such and such. Review of suspension dated such and such. The competent authority, DIG Chief Security Commissioner Southeastern Railway, has accepted the recommendation.
Today, court is considering disciplinary proceeding. Charge sheet is issued from Chakradharpur.
Suspension is the part of the cause of action of the disciplinary proceeding. Suspension, and not only that, the review committee, your lordship, kindly come to the review committee. Order of the review committee. Page 29. Who is the authority, my lord?
Where is the notice? Where is the notice of inquiry? Show me the notice of inquiry. Inquiry notice.
Inquiry notice.
Yes. You are asked to appear before the inquiry officer.
Yes.
Where is that notice?
No, that is in memorandum.
Page 31,
Memorandum, page 31.
Odisha, Chakradharpur. Page 31, Chakradharpur.
That's it. Let me place my submission.
Where inquiry was scheduled to be held? The inquiry is fixed on 16th October 2025 at 10:30 a.m. Regional at Railway Protection Force Post BUF. You should attend the inquiry, failing which the inquiry will be conducted ex parte. Where inquiry is scheduled to be held?
But that is also Chakradharpur.
That is also Chakradharpur
Then,
mentioned here.
but my lord, I am not on that question.
And FIR also lodged at Chakradharpur.
Question is this, my lord.
And that FIR has not annexed in this writ petition. But
Yes, please allow him. Now you have taken this point, allow him.
Lordship, my lord, the suspension is the part of the cause of action. Lordship, kindly come to page 27. The review committee was constituted by the DIG cum Chief Security Commissioner South Eastern Railway. Part of the cause of action arises within the jurisdiction. Lordship, kindly read. DIG cum Chief Security Commissioner South Eastern Railway. Review of suspension dated such and such the competent authority, that is DIG cum Chief Security Commissioner, appellate authority has accepted the recommendation.
Where?
Now, my lord.
Page 27.
Page 27. Lordship, kindly read the page 27.
Appellate authority.
I have challenged this order also in my writ petition.
That is also from Chakradharpur. That
No.
letter.
Please tell me, please allow me to read the DIG cum Chief Security Commissioner South Eastern Railway, Garden Reach, GRC, Garden Reach.
Page 27 you are saying, showing Chakradharpur. Page 27.
Who communicated the order?
That is why I am pointing out this also order has been issued, letter has been issued by the Chakradharpur.
And the suspension order was extended as per the direction of the Deputy Inspector General, South Eastern Railway, Garden Reach. And he also, my lord, framed the committee. Let's say, kindly see the committee. Who are the member of the committee? I also challenge this order before your lordship. This is one of the part of cause of action.
What is DRC CKP?
Garden
DRC?
Reach.
No, DRC.
GRC means Garden Reach. My lord, in short, GRC.
DRC. DRC, not GRC.
D.
DRC means
Deputy Railway, Divisional Railway.
Commissioner. Chakradharpur. Now, please read it. As communicated by DIG, DIG comes so-and-so, office letter number so-and-so of suspension dated 16 September 2025. The competent authority, that is DIG comes CSC so-and-so, GRC appellate authority, has accepted the recommendation of suspension review committee dated 8 September 2025 in connection with the suspension case of petitioner Inspector so-and-so, now attached to DRC Chakradharpur.
Attached to DRC.
But not only this, your suspension letter was also issued from Chakradharpur. Only this competent authority, it is stated that it so-and-so, the competent authority, that is DIG comes CSC, RPF, ACRC, Garden Reach, appellate authority has accepted the recommendation.
Accepted, appellate authority, yes.
By that, the jurisdiction cannot be conferred.
That's a part of the cause of action.
No,
Lordship,
because your suspension letter was issued from Chakradharpur.
yes, that may be.
Then charge sheet was issued from Chakradharpur. You are posted at Chakradharpur. Only aberration is this, that this it is accepted by the appellate authority, which is at guardianage.
Yes.
That only suspension.
Now, my lord, review committee, my lord, was fed as per the direction of the DIG cum Chief Security Commissioner. Lordship, kindly come to the review committee report. Who is the member of the review committee? Lordship, kindly come page 30. One of the member of the DSC Kharagpur of the review committee. Lordship, kindly page 30. Prakash Kumar Panda, senior DSC RPF Kharagpur. So he is one of the member. He recommended.
But two other members are at Chakradharpur.
Yes, and another member is DSC RPF Chakradharpur. So, my lord, I am affected by the recommendation. So I have challenged the review committee.
What is this recommendation?
The lordship kindly come to join prayer. I have challenged.
Where is your suspension letter?
My lord.
Where is your suspension letter?
Suspension page 21. Sir.
Annexure 1.
Page 21.
Page 21. আমাকে ওখানে একটা বই আছে, বইতে দাও।
Chakradharpur.
Not only that, there is a reported judgment on this matter. So I am affected.
Moreover, incident took place in Odisha, based on which proceeding was initiated.
Lordship, kindly.
Esho.
Lordship, my lord, I am giving the judgment also.
Yes, yes.
But the same point, identical point, division bench judgment also there.
Petitioner has affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner has questioned authority of inquiry officer in terms of
Lordship, kindly consider
48.1
11, 12 and 13
of the Railway Protection Force Rules
division bench
1987
judgment.
of the Railway Protection Force Rules 1987.
I am handing over, my lord, this book.
Railway কি বলছিলাম? To conduct inquiry in connection with charge sheet issued on 6th October 2025. And it is also submitted that without giving any reply, without giving opportunity to the petitioner to furnish reply to the charge sheet dated 6th October 2025. Date of inquiry was fixed by the inquiry officer on 16th October 2025. Stop. In the writ petition, prayer is made. Now, in the writ petition, suspension order dated 18th May 2025 and initiation of proceeding, the initiation of departmental proceedings based on charge sheet dated 6th October 2025 are questioned. Next paragraph, learned advocate representing Southeastern Railways.
Yes.
Has questioned maintainability of this writ petition on the point of jurisdiction. Stop. It is submitted that cause of action arose in Odisha. It is submitted that entire cause of action arose in Odisha. Therefore, this court does not have territorial jurisdiction to entertain this writ petition. Stop. On perusal of relevant documents available on record, it appears petitioner being member of Railway Protection Force or being inspector of Railway Protection Force is posted at Bimalgarh under Chakradharpur Division of Southeastern Railway. Stop. Suspension order was issued by the Senior Divisional Security Commissioner, Southeastern Railway, Chakradharpur, Odisha. Charge sheet dated 6th October 2025 was issued by the Senior Divisional Security Commissioner, Southeastern Railway, Chakradharpur, Odisha being the discipline authority. Next paragraph. In order to satisfy this court on the point of jurisdiction, attention of this court has been drawn to a document at page 27 of the writ petition dated 17 September 2025. And it is contended based on said document dated based on said office order dated 17 September 2025. That appellate authority at Garden Ridge, West Bengal, accepted the recommendation of suspension. Review committee dated 8 September 2025. Therefore, part of cause of action arose within the territorial jurisdiction of this court. Stop. Court is not impressed
Lordship, kindly take one note.
on the
One
submission
page, one
made on
document.
behalf of the petitioner that part of cause of action arose within the territorial jurisdiction of this court. Taking note of the suspension order dated 18th May 2025 issued by the concerned authority of Southeastern Railway from Chakradharpur, Odisha, and charge sheet dated 6th October 2025 issued by the disciplinary authority whose office is at Chakradharpur, Odisha. Stop. Mayor approval of appellate authority at Garden Ridge on recommendation of suspension review committee as accorded vide office order dated 17 September 2025 does not comes in aid of the petitioner in order to substantiate that part of cause of action arose under the territorial jurisdiction of this court.
Well, kindly consider this judgment.
Next paragraph.
Lordship, this judgment, Lordship, kindly consider.
Moreover, the incident based on which complaint was lodged against the petitioner took place at a place to in ki bolle moreover now occurred at a place within the state of Odisha, as a result whereof criminal case was filed by the petitioner before the High Court of Odisha at Cuttack, being ABLAPL number 6212 of 2025. Stop. Next paragraph. Accordingly, it is concluded that this court doesn't have territorial jurisdiction to entertain the writ petition. Stop. Writ petition stands dismissed on the point of maintainability. Now, on the point of jurisdiction, However, this order shall not preclude the petitioner to approach the High Court having jurisdiction to examine the issue involved in this writ petition. Urgent Xerox certificate copy.
Lordship, kindly record this judgment. This judgment, division bench judgment.
Leave it out.
11, 12, and 13. Paragraph 11, 12, and 13. Division bench judgment. 11, 12, and 13. 13 is most, paragraph 13 is most important.
What happened to This judgment is based on an admitted fact.
Yes.
That a registered office is at Buidhum.
Yes. My register office is regarded is Southeastern.
Yes, but this is entire proceeding was initiated from Odisha. You have approached the Odisha High Court for obtaining bail.
226(1) court also held. Your Lordship kindly read paragraph 12 and 13. Especially
ওখানে
13.
যেখানে সাবমিশনটা করেছেন ওখানটা করে দেবে যে রিলায়েন্স ইজ প্লেসড অন দ্য জাজমেন্ট অফ দ্য অনারেবল ডিভিশন বেঞ্চ reported in 2006-3 SLR within bracket Kollan Banerjee versus Eastern Coalfields Limited and others, close bracket. স্টপ না একদম শেষেই করো লাস্ট প্যারাগ্রাফটা কি বললাম এই সেন্টেন্স প্যারাগ্রাফটার আগে একটা জায়গায় করো রিলায়েন্স ওয়াজ প্লেসড অন দ্য judgment of the Honorable Division Bench reported in 2006 3 SLR within bracket Kullan Banerjee versus Eastern Coalfields Limited. But considering the facts of the case, this court finds that the ratio of Kullan Banerjee Supra does not come in aid of the petitioner. এটা নিয়ে নাও রেফারেন্সটা নিয়ে নাও yes
Paragraph item number 11 also same order.
Next matter.
11 is same matter.
Same
order.
Item number 11.
আমাকে রুলের বইটা দিন তো
এই একটা বই আনিয়ে ছিল
Only post is head constable, but he was in that
suspension order date. Where is the suspension order?
suspension order P1.
এসো same order বলছে দেখুন
Page 20.
Where is the suspension order?
Page 21, my lord. Same order.
Annexure P1.
Annexure P1.
দেখো তো suspension order 10th May 2025 ছিল না
কোথায়
10th May.
18th May তো8 May 2025
Yes.
suspension order 8 May 2025 Mr. Mojumdar, where is the document relating to approval by the appellate by the appellate authority relating to suspension which you have relied upon?
My lord, your lordship, kindly come to my paragraph. I have totally dealt with the matter. Page 26. My lord, paragraph 26, page 12.
No, where is the document which you have relied in previous matter
Yes, review committee.
in order to substantiate that review committee approved the recommendation of suspension?
One of the member of the review committee, my lord.
Yes, where is that document?
Assistant Secretary Commissioner of Health. My lord. Page.
Railway Protection Force 1957. There is no such document.
My lord, I
Annexed like
have annexed. Review committee, I have annexed.
Which page?
Page 27, perhaps.
27.
Not legible one. Page 20.
page 27 to
Yes,
29.
yes.
29, Malak, one of the member
29.
belongs to Kharagpur. Page 29. S. Diggi, Assistant Security Commissioner, Works of Kharagpur member. He is one of the member.
Not judicial.
On the basis of his recommendation, my lord, my suspension period was extended for a further period of 180 days. And that order I have challenged in this petition. Paragraph 26, my lord, I have dealt with the matter. Paragraph
Now, page 27.
Yes, yes.
Come to page 27. First line, page 27. Appellate Authority, Senior TSC, RPF, Chakradharpur.
Yes.
It is not at Garden Reach, like previous matter.
Yes, yes, that is true.
In the previous matter, in order to substantiate your case, you submitted that Appellate Authority is stationed at Garden Reach. Hey, again, file ta dao to.
Yes, yes. That
It is at Chakradharpur.
This is Chakradharpur.
Now,
In previous matter, the appellate authority, my lord, considered the recommendation of the review committee and extended the period of suspension. Philosophically did the order extended the period of suspension for another period of 180 days.
here is no intervention of competent committee, but the appellate authority is referred to in your previous matter. It is competent authority, that is DIG cum CSC, that stationed at Garden Reach. But in this case, there is no such intervention by an authority whose office is at Garden Reach.
Yes, well, that is accepted fact.
Yes.
But your lordship, kindly see, the member of the review committee,
No,
Yes, 29.
it is না এটাকে একভাবে সেই এক ফর্মুলায়
Assistant Security Commissioner of Kharagpur, he is one of the member of the review committee,
যে
and I have made him partner.
Not really. Fine.
পড়াটা পড়ো হ্যাঁ 18 September 2025. September. তারপর পড়ো দাঁড়াও এক মিনিট সাসপেনশন অর্ডার dated 8 May 2025 দাঁড়াও তো এটা কি আমি ভুল বলেছি না 8 May 2025 হ্যাঁ না ভুল না 18 May হ্যাঁ এখানে 8 May হবে জাস্ট জাস্ট May 2025, yes. এখানে 8 May হবে হ্যাঁ দাঁড়াও এটা দেখে নিও চার্জশিটটা। Where is the charge sheet? In the second matter,
My lord,
page 30.
Second, my lord.
Page 30.
yes, my lord. Page 30, P5. Final purchase.
হ্যাঁ কি বলছো রে বলো একবার চার্জশিট October 2025 দেখে নিই দাঁড়াও। Yes. এইখানটা একটু চেঞ্জ হবে। In the present case, appellate authority stationed at Chakradharpur, Odisha, accepted the recommendation of review committee relating to suspension. Therefore, there is no question of arising part cause of action within the territorial jurisdiction of this court. তারপর পড়ো ওই সেন্টেন্সটা এইভাবে সাবস্টিটিউটেড হবে। Occurred. দাঁড়াও criminal cases. Where is the document relating to the criminal case in the second matter? I think petitioner has not approached the High Court.
FIR, my lord, page 50. 50.
এটা দেখলাম।
Bottom name is there, one. Page 51 bottom.
As a result whereof, a criminal proceeding is pending before the special judge, CBI, Bhubaneswar, being RC case number 04 within bracket capital A, close bracket of 2025. দাঁড়াও তারপর এই ওনার যে জাজমেন্টটা উনি রিলাই করলেন ওটা কোথায় দিলেন? না অ্যাকর্ডিংলি ইট ইজ ডিসাইডেড, তার আগে জাজমেন্টটা বলো, কি সেন্টেন্সটা বলো? Stop. আর একটা তারপর একটা সাব প্যারাগ্রাফ করো, বিফোর পার্টিং উইথ it needs to be observed that primarily petitioner is aggrieved by the charge sheet dated 6th October 2025, whereby a person who has been appointed as inquiry officer, according to the petitioner, is not authorized to conduct inquiry in terms of Rule 248.1 of the Railway Protection Force Rules 1987. Such inquiry is to be conducted at a place which is not within the territorial jurisdiction of this court. Therefore, this court does not find it fit to intervene with the said inquiry proceeding, as it is found that this court does not have territorial jurisdiction. তারপরে করে দেব।
My lord, your lordship record the judgment which I have cited.
Yes, I have referred. Kalyan Banerjee, I have referred. এটা একটু আনি নেই।
আমার বল।
Item number 12.
My lord, I beg to appear on behalf of the petitioner in this matter. Issue my service upset. All are served? Yes. My lord, it is petitioner was engaged as a constable at BSF. My lord, what happened? It's a very interesting case of being punished for being namesake.
Your Lordship, may I? I'm appearing for the respondents, BSF. Your Lordship, Union of India has not been served through Ministry of Law and Justice. So they have not been able to appoint any advocate. And as a result of which, the
You are
appointment
representing whom?
on behalf of BSF on request that the matter has been listed, it was directly served in Delhi. It ought to have been in the affidavit of service. It will appear, Your Lordship. Ministry of Law and Justice has not been served. Respondent number 1 is it may come back on Friday, coming week Friday, so that in meantime they take 48 hours for service to
It has been
complete.
served upon the Ministry of Law and Justice at Kolkata.
No. Told it has not been served.
It has not.
It has been served to the union and other BSF authorities.
And there is a communication we all we have.
There is interdepartmental communication. I know the engagement possible, right?
Your Lordship.
Yes. Engagement. It will be affidavit service type of thing.
নেই আমি MOL থেকে কনফার্ম করেছি।
আচ্ছা ঠিক আছে, নো প্রবলেম। লিভ নেওয়ার দরকার নেই, এটাই ইউনিয়ন এতে পাঠাতে হবে। লিভ নেওয়ার নেই তো কিছু, পার্টি অ্যাড করার নেই তো।
পার্টি 1 আছে তো।
আছে তো।
সার্ভিস করে দেবে।
সিনিয়র অ্যাডভোকেট 6 6 নম্বর ইতে না
স্ট্যান্ডার্ড 11 স্ট্যান্ডার্ড।
কাকে অ্যাড্রেস করতে হয়? কাকে অ্যাড্রেস করতে হয়? এটা কি জানেন দিদি?
This branch secretariat, Ministry of Law and Justice, to be served. You have served.
No, they
Not
could
to
not.
this authority, but to BSF and Union of India have
So
served.
they then serve and come
Through
back.
this, yes.
Yes.
May I take back the affidavit of service there?
Yes.
Take
it back. Learned advocate representing the petitioner petitioner submits that branch secretariat, Ministry of Law and Justice, branch secretariat Kolkata, Ministry of Law and Justice is yet to be served. Stop. Learned advocate for the petitioner is directed to serve upon Ministry of Law and Justice, branch secretariat Kolkata by Friday.
Yes,
By Friday and file affidavit of service on the next day. Hearing of this matter, list the matter under the same heading for further consideration on Monday next, 17th November 2020.
Instead of 17th, can it be on 18th?
You have difficulty?
On 18th or 19th, my lord. I have other
The
matters.
19th November.
Grateful to you. Much obliged.
You obtain instruction.
Your Lordship.
Item number 14.
Item number 14, I am for the petitioner lordship.
in this matter, Lordship, relating to the PF of the Dunlop India Limited workers, Lordship. It is mistakenly filed in Group 6, my Lord. It could be filed in under Group 3.
Group
it's a,
3.
It's a clerical mistake, Lordship.
Issue.
Lordship, release the matter and liberty to mention before the appropriate bench.
Client advocate representing the petitioner submits issue involved in this writ petition relates to Group 3 of classification list of different types of writ proceedings. Stop. Hence, a writ petition stands released due to want of determination and be placed before the appropriate bench. Leave is granted to the petitioner to amend the presentation form and pro forma page of the writ petition and reclassify the writ petition accordingly. You have classified it as Group 6. It should be classified as Group 3. Do it and it will be sent to the appropriate bench. Next.
Item number 15.
Respondent 2, 3, 4.
My lord, I am in for the respondent, my lord.
Yes.
Union of India is a necessary party, but he is not implicated the party, my lord, in this matter.
Your Lordship, Mr. Chakraborty is appearing on behalf of the petitioner. He's in some personal difficulty. Your
Chakraborty.
Lordship. Mr. Orin Chakraborty.
Anil Chakraborty.
He's in some personal difficulty, Your Lordship. I'm praying for not today.
You are the advocate on record.
No, Your Lordship.
Priyanshu Kotari.
No, Your Lordship.
Well, let the petitioner be represented. Then you take this point. Issue.
Kindly please on 20th, my lord.
At the time of call, accommodation is paid for on behalf of the petitioner. On behalf of the petitioner, stop. Union of India is represented by learned advocates. Next paragraph, hearing of this matter. List the matter under the same heading for further consideration on (17th).
No, I'm not available, my lord. 20th, my lord. Other matter is fixed before your lordship, my.
You are not available on 17th.
17th and 18th.
19th.
19th. Banaras जा रहे हैं.
এটা না ওই যেটা ডিকটেশন দিলাম ওর সঙ্গে দিয়ে দাও যখন প্লেসড হবে এটা আমার লাগবে না এটা আমার লাগবে তখন হ্যাঁ হ্যাঁ চেম্বারে পাঠিয়ে দিলেই হবে
Item number 82 from monthly list.
I am for Union of India.
For the petition. Take my affidavit of service. But the petitioner before your lordship, my lord, is the head constable of the border security force. My lord, he was inducted in the service in 1990. And my lord, several other persons, my lord, have been inducted in the service with the petitioner in 1990 on the same date. My lord, what happens? Eventually, my lord, he came to know that he did not have any disciplinary proceeding pending against him. My lord, he did not have any adverse remark in his APARs anywhere, any other adverse my lord, thing against the petitioner. He found, my lord, that he is getting lesser pay than the colleagues of him. For which, my lord, let us say, my lord, he is getting 49,500. On the other hand, all other persons are getting 51,000 and odd.
So it's a case of pay disparity.
Pay disparity. My lord, he makes an application, representation to the authority. The authority, my lord, forwards it to the higher authorities that what is the difficulties in that. My lord, after that, nothing happened. I have come before this one.
Have you made any representation? Let it be considered first by the authority.
May I just take your lordship?
Why
to the
court will adjudicate it before from the administrative side any decision is taken?
I think, my lord, there has been a mistake on their part, perhaps. Otherwise, there is no other reason. If they could have come to your lordship with any report, if I just could take.
Where is the representation?
My lord, before representation, could I take your lordship to the disparity once?
No.
Very
I know no discrepancy. Here is the calculation.
Page number 35 would be my representation.
Page 55.
35.
Page it's not required. Please wait. I have not called for any report. Page 35.
Yes, ma'am. I am not placed because it is in handwriting.
No. Wait. Who is to take decision?
My lord, page number 35, the commandant of the battalion of Kollani.
Yes,
But my lord, the higher authority to this, who is responsible for the pay, your lordship will find at page number, my lord, 2.
এই শুভজিৎকে ডাকো তো শুভজিৎ উনি কি অ্যাপিয়ার করছেন এই ম্যাটারে? You are appearing for?
I'm for the student 1 to 6. Union of India.
Union of India.
You are also.
Union of India.
I am junior. Is senior.
Yeah.
Mr. Gupta.
Who is the appropriate authority to decide the representation of the petitioner?
It I did not receive any instruction, my lord. So some instruction is required.
It's my number 5, my lord. Page number 2 I have mentioned.
Inspector General Frontier Headquarters.
BSF.
Who is the appropriate authority to decide the representation of the petitioner?
Till instruction is given by the
Who is the
defendant.
appropriate authority to decide the representation of the petitioner?
BSF. Head constable of the my lord.
Yes. Inspector General Frontier Headquarters,
Yes.
BSF, South Bengal.
Second in command for commandant of BSF. 36 battalion of BSF.
So that is the instructing authority to you. My lord is asking.
But he has not been made party.
No, my lord. My learned senior is referring, my lord, the person who has given instruction to my learned senior.
This is an instruction. So
Now, it is a case of pay disparity. Rightly or wrongly, a grievance has been raised. Now, it is to be decided whether it is a case of pay disparity or not, considering the pay of similarly circumstanced other employees. Now, other member of the BSF force. Now, who is to decide it?
respondent number 5, Inspector General.
Make a representation.
I will do that.
You are working as
Head constable.
Head constable.
General duty.
Oh, 6. Oh, no. 6. Eastern Command. Frontier Headquarter, BSF. ও আচ্ছা আচ্ছা সেটাই তো বললাম my lord, responding.
No, let it be decided by respondent number 5, Inspector General. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. It is submitted by the learned advocate representing the petitioner that he was appointed as initially appointed as constable. Petitioner that he was initially appointed as constable in border security force for short BSF. Close bracket. Subsequently, stop. At present, petitioner is working as head constable. Stop.
My lord, here
it is contended that that there is pay disparity, considering the pay accorded to similarly circumstanced other head constable or similarly circumstanced persons working in identical posts. Working in identical posts. Stop.
Sir, instruction copy আছে আপনার কাছে একটু
দেওয়া যাবে। My lord, may I permit?
Next paragraph. Respondents are represented by learned advocate who has disputed the contention of the petitioner. Stop. Next paragraph. This court does not find enough. No purpose would be subserved in considering the issue involved in this writ petition. No purpose would be subserved in keeping this writ petition pending. Next paragraph. Leave is granted to the petitioner to make a representation to the Inspector General, Frontier Headquarters, BSF, being respondent number 5. BSF South Bengal. Yes. Being respondent number 5. Claiming pay parity, considering the pay accorded to similarly circumstanced those who are holding identical posts.
Great.
By fortnight from date. Stop. If such representation is made within the aforesaid time, respondent number 5 shall decide the same in accordance with law by 8 weeks thereafter, and decision to be communicated to the petitioner by fortnight thereafter. Stop. Writ petition stands disposed of, urgent thereof. Next.
My lord.
Item number 88.
For the petition in this matter, my lord. The petitioner before your lordship is the widow of the deceased employee working at, my lord, NTPC. Now, my lord, after the death, my client, being the widow of the deceased, made an application for disbursement of all retired dues.
Who is appearing for the respondents?
Your Lordship, I'm appearing for the respondent.
I have served everyone.
7.
There.
And
This is my evidence service, my lord. I have served everybody.
Yes. What is your case?
Now, my case is, my lord, she is the widow of the deceased. After the death, my lord, she, my lord, sought for the all benefits which are lying, my lord.
Petitioner is the widow.
Widow of the deceased employee. Deceased was, my lord, working under the, my lord, NTPC. National, my lord, Thermal Power Project Limited.
Yes.
At, my lord, Malda. Now, after the death, my lord, she, my lord, sought for the all benefits, including PF, gratuity, all benefits which
when husband died,
my lord. Death certificate is at, my lord, page 21. April 2021.
Yes.
My lord, page 28, my lord, they sought for, my lord, the succession certificate.
Why? Petitioner is not the nominee.
Nominee, but still, my lord, they sought for the certificate. I have, my lord, deposited.
Page 28.
Page 28. Subject, kindly see, requirement of succession certificate for settlement of the terminal benefit in respect of late Jivan Kumar Nag, employee such and such. Be that as it may, my lord, my lord.
Yes, be that, yes.
I have also, my lord, applied
submitted succession
certificate of the such. Now, my lord, by this time, my lord, one person, that is, my lord, I have made him, my lord, also party to these proceedings. My lord, he, my lord, wrote a letter to the, my lord, authority. And, my lord, he also filed one application
claiming to be a son of the deceased employee from the first wife. Now,
That's why succession certificate was sought.
yes, but there is no challenge of the succession certificate as yet. So now, my lord, he also filed one case at, my lord, Delhi, not here. That is pending without any order. I have also, my lord, made objection to that certificate, to that application at that, my lord, court at Delhi.
So array him party.
Yes, I have already made him party. Copy has already been served to him. He has also received. Now, my lord, the benefits which are lying before them.
The first one is still alive.
No, he died long before.
She's alive. The first wife is still alive.
Divorce.
Divorce.
Sorry, my lord, this is a case of divorce. Sorry, I may be, my lord, rectified. He
There is a dissolution of first marriage.
Dissolution
Your
first marriage.
Lordship, there was a dissolution of the first marriage, and private respondent was born out of the marriage. And now the private respondent is asking for the succession. Like, he have initiated this legal proceeding, which is going on and
Seeking what?
he's seeking succession and share of the benefits that is lying with us, the terminal benefits.
The son has the right to get the benefits.
Well, son has not challenged the succession certificate issued from the competent court.
Maybe, but the succession certificate is not sacrosanct.
But then, my lord, he has.
Son has the right. Yes, wife does not have any right after dissolution.
My lord.
Now, but if the child born in the wedlock is entitled to get the benefit.
Entitled to get the benefit, my lord, subject to, my lord, because he is not the, my lord.
How you can ignore the right of the son, right of the son who was born in the wedlock, so far the first marriage is concerned.
First marriage. Now, my lord, in the service record, nowhere his name is mentioned.
That cannot be.
No, I am not on that.
That cannot be denied on the strength of.
Yes. I am not on that. Now, my lord.
Therefore, taking note of the presence of son,
my lord,
that son, proportionate amount can be released in your favor.
At this stage.
Not the entire amount. Not at this stage.
My lord.
Finally, proportionate benefits can be released in your favor. Son has got the right.
My lord, son has got the right. Now, my lord, succession certificate is not under challenge by anyone.
There might be a divorce, decree of divorce,
my lord.
But still, son remains the father.
No, I am not on that.
The relation between father and son remains.
Subject to, my lord, proof of his, my lord, being a son, because I was not.
Then you file a civil suit, get a declaration. Court will
the succession certificate is there. Either one, my lord.
No. Succession certificate will not come in your aid.
And my lord, the son has also, my lord, filed one, my lord, application that is at Delhi.
Let me
not
dispose
here.
of the writ petition granting you leave to obtain a decree. Or obtain a decree of declaration that you are the only heir.
At this stage, my lord, may I pray, my lord, if your lordship direct them to release, my lord, the admissible dues which are payable to the widow, because family pension will not get the, my lord, son. Other benefits.
So far, family pension is concerned, that son will not get.
Son will not get. And other benefits, 50% may kindly, my lord, release, because 50% I am, at least I am entitled.
Court orders the 50%, there is no problem to us. If my lord court direct us, there is no problem. The 50% amount should be disbursed.
Let family pension be paid to the petitioner.
According to the formalities of there should be formalities, all the formalities we can consider.
Now you file a report that as to why till date it has not been released. Based on in consideration of that report, I will pass on. Something must be on record, not on the basis of oral submissions. Issue.
Your Lordship.
Okay.
Your Lordship, may I just make one submission? Your Lord, may I please have your kind attention on the cause list of this writ petition?
Yes.
On the cause list of this writ petition, cause title of this writ petition, the name of the respondent number 1 is incorrectly admissible over here. It is written as National Thermal Power Corporation Limited, and it was changed in 2005. In the beginning of the entities here.
Respondent number 1, National Thermal Power Corporation.
Yes, Your Lordship. So, Your Lordship, this name was the former name of the company of the respondent number 1, which was changed in 2005, October.
to be
When it was
NTPC
changed?
2005, year 2005, October, and it is now NTPC Limited only. So your lordship, please direct that the correction should
It
be
is National NTPC Limited.
NTPC
That is
Limited.
National Thermal Power Corporation
But
Limited.
your lordship, it is changed that way only, that it is this is the former name, but now it is used as it is.
But the short form of National Thermal Power Corporation Limited is
Your lordship, it is not the short form, it is the normal name right now. It is changed in that way only.
issue.
correct করে দিতে হবে। NTPC যেটা আছে মানে কেটে
Affidavit of service. Affidavit of service.
Yes, yes, I have given, bro.
Affidavit
I
of
have
service
every word.
on behalf of the petitioner is taken on record. Next paragraph. Husband of the petitioner was an employee of NTPC Limited who died in harness or
No,
after retirement.
Died in harness.
Died in harness. Who died in harness on 17th April 2021. Grievance of the petitioner is till date retirement dues are not retirement dues till date retirement dues including pension are not paid to her. It is also submitted that as per direction of the concerned authority of NTPC Limited, legal heir certificate was obtained by the petitioner. Where is your legal heir certificate?
Page 39. Page 40 is the specification of the amounts. Page 41. The certificate is accordingly granted to the petitioner Mitali to collect those dates and securities.
Page 41.
41, my lord. The certificate is accordingly granted to the petitioner Mitali.
হ্যাঁ কি বলছিলাম legal heir certificate was obtained and it was submitted before the concerned respondent authority.
But this succession certificate, my lord.
Oh, yes, succession certificate was obtained and it was submitted for expeditious settlement of dues. Next paragraph. It is submitted on behalf of NTPC Limited that husband of the petitioner previously married another lady, but there was dissolution of first marriage and subsequent thereto petitioner subsequent thereto employee married to the present petitioner. Stop. In the first wedlock, respondent number 8 was born, and as such, respondent number 8 has claim on provident fund and gratuity. Stop. it is submitted, it is also submitted that son, it is also submitted that respondent number 8 is not entitled to receive family pension, and petitioner, being the wife of the deceased employee, is entitled to receive family pension. Next paragraph. Concerned authority of NTPC Limited is directed to file a report in the form of affidavit disclosing the entitlement of the petitioner to receive family pension and proportionate retirement dues by 10 days from date,
Let's have more time, please.
by fortnight from date. Stop. Copy of the report shall be served upon the learned advocate representing the petitioner. Next paragraph. Leave is granted to the learned advocate for the petitioner to describe NTPC Limited appropriately in the cost title of the writ petition in course of this day. You assist him in course of this day. Stop. List the matter under the same heading for further consideration. On 2nd December 2025. I will let the matter be placed in the supplementary list since it's a matter of family pension.
Grateful, Your Lordship.
Now it is only NTPC Limited, not National Thermal Power. Yes.
Item number 98.
এটা কত করে দেবো? 88. Now it is 98. Yes.
This matter, Mr. Muridujaman appearing on behalf of petitioner, he has not come on. My Lord, saying not this.
Not today.
Item number 101.
In this matter, Mr. Galivi is appearing, my lord. He is engaged in court number 16, my lord. Can it be not this week, my lord?
Not this, why not tomorrow?
My lord, he is not available, my lord, tomorrow.
Well, come back.
I just seek one permission. I will make certain submissions which are not pleaded. May I just write a short note?
Yes.
Short note on the pleadings, added pleadings.
No, it is on the point of maintenance. No note. Come back, not this week.
Grateful, my lord.
Only on the point of maintenance. Record and order. Matter is taken up for consideration when accommodation is paid for on behalf state respondents.
My lord.
Accommodation is paid for on behalf of the state respondents. Stop. Hearing of this matter stands adjourned till Monday next, 17th November 2025.
Grateful, my lord.
Item number 104.
We appear for the petitioners, my lord. Petitioner, my lord, was a sub-assistant engineer of PWD roads. My lord,
how reputation is maintainable?
That is the reason my learned junior who has, I was telling him that probably this petition is, it should go to the tribunal because it's government of West Bengal's cadre. My lord. My lord,
Issues, my lord. Learned advocate representing the petitioner has clearly submitted has fairly submitted that petitioner is a state government employee
So he is super
working as petitioner was a state government employee, working as who was working as sub assistant engineer in
PWD roads.
PWD roads.
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 ROADS Roads Directorate.
Directorate. PWD roads direct. Where is the specification
Malad,
so far the department is concerned?
The first annexure.
Yes.
Except
my lord, may I submit the report, my lord?
this is the
Not necessary.
pension order. And my lord, the representations are all there.
Where it is stated that petitioner was holding which post in which department?
My lord, the representation suggests.
Page.
My lord, it starts from page 15 onwards. And there was an RTI application file reply to that effect, although the reply is not annexed. And the PPO is at page 22.
কি বলছিলাম?
Page 25 is the description.
State government employee. Who was what? State government employee.
Junior engineer. So he retired as junior engineer.
PWD, sub-assistant engineer, PWD.
Junior engineer.
Stop. Next paragraph. In view of such submission made on তারপর একটা লাইন অ্যাড করে petitioner retired on superannuation. Stop. You have prayed for consolidation of pension.
No, my lord, CAS benefits. Although the promotion he was entitled to
Career advancement benefits.
25 years of the benefits, and although he was entitled to promotion, but he was belatedly.
Petitioner has paid certain benefits relating to the service rendered by him before his retirement. Next one. Hence, it is found at this stage, writ petition is not maintainable. Stop. Writ petition stands dismissed. However, this order shall not preclude the petitioner to approach West Bengal Administrative Tribunal on the self-same causal action.
Although in one of the representation it suggests that he was posted at
Parties to act on the server.
Highway divisions. There are separate divisions. One is roads and one is highway divisions. One representation suggests. Service.
Yes.
Item number 112.
Lordship, Mr. Anindo Bose is appearing for the petitioner. Anindo Bose. Mr. Anindo Bose is appearing for the petitioner. He is engaged in court number 14.
The last
I am praying for
The last officer asked me to whether I have Bogalma or not, but I
Now
find
you don't. Yes.
I found for record that Bogalma was not filed. I carried
What you have found?
Bogalma was not filed.
Was not filed.
Was not filed. I am filling Bogalma.
You are representing which respondent?
5 and 6.
দেখি দাও তো। At the time of call, issue. At the time of call, accommodation is paid for on behalf of the petitioner. Stop. Respondent numbers 5 and 6 are represented by learned advocate. Stop. list the matter under the same heading for further consideration on 19th November 2025. You file it in the department.
Right. Item number 114.
Paying for the petitioner, Your Lordship.
I appear for the Calcutta State Transport Corporation.
I am for the state respondents.
Lordship, this is the matter regarding the non-payment of family pension to the petitioner. The Lordship, this petitioner's husband was an
Widow.
employee. Lordship, she is a widow of the employee of the Calcutta State Transport Corporation. So, Your Lordship, as per Regulation 6(1) of the Calcutta State Transport Corporation Death Cum Retirement Benefits, an option has to be exercised for coming into the purview of the DCRB scheme for getting the pension, Your Lordship. So he opted for pension within the prescribed period, within 6 months of the notification, Your Lordship.
Within 6 months?
Within 6 months of the publication of that notice that you have to exercise your option for getting the pension or to come under
So
the.
that was exercised.
That was necessary and that is mandatory, Your Lordship. And now, my Lord, kindly come to Annexure P1. It says that this is a letter by the Joint Secretary to the Government of West Bengal to the Managing Director of the Calcutta State Transport Corporation. I am directed to refer to a letter number this and this on the subject noted above and to say that the Finance Department has informed their inability to agree with the proposal of the withdrawal of the option for pension by the employee as there is no scope in the CSTC DCRB regulation for re-option to remain outside the pension scheme after exercising option to be guided by the said regulation. So, the moment you opt for pension, that is final. And
You cannot resile.
Lordship, you cannot withdraw or opt out from the said scheme. So that is the final one. But to be very clear before Your Lordship, the petitioner in 2004, he made an application to Calcutta State Transport Corporation for withdrawal of his option, Your Lordship, which cannot be done. I admit it. He made an application. And now, Your Lordship, kindly come to Annexure P5 at page number 21, Your Lordship. Lordship, Lordship, the Calcutta State Transport is a prayer of Sri Uma Shankar Chakravarti, the husband of the petitioner, Your Lordship. Here, it is the first paragraph. This case is taken up on the basis of the representation dated this and this. Has prayed for withdrawal of his option for pension exercised by him or her under the CSTC employees DCRB regulation. It reveals from the record that he submitted his option for pension under the CSTC employees DCRB regulations within the prescribed period of 6 months as envisaged from the original provision made under the regulation 6(1) of the DCRB regulation 1990. So this is final. It is evident that he opted for pension. So now, Your Lordship, on the advice of one senior advocate of this honorable court, his withdrawal for option was accepted. When they accepted the withdrawal, Lordship. Now, Your Lordship, come to annexure P6.
Where is acceptance recorded?
Lordship, the acceptance is written in
page 21.
Lordship, now page 21 is the annexure P1. So, Your Lordship, it was.
No, annexure P1 is page 50. Page 21 is annexure P5.
Lordship, P5 is the annexure. Your Lordship, it was accepted.
Show me how it was accepted.
Lordship. Lordship, kindly come to page number 22, the next very page, paragraph number 2. It thus appears that has paid for withdrawal of the option mainly on the ground. My Lord has got it.
Yes.
Lordship, that there is no certainty of the payment of the pension on regular monthly basis, as because the pension at that point of time in CSC was very irregular. That's why he was compelled to withdraw his option. So she has stated that she is in urgent need of money to meet or her the current requirement. Learned advocate Mr. Vikas Chandra Bhattacharya has observed that such case should be considered. This is solely to provide relief to the retired employees as paid for. So, Your Lordship, this is a fact.
So that you can get the lump sum amount.
No, Lordship, I'm coming. Now, kindly come to page number 24, annexure P6, Your Lordship. So
that is for your own benefit it was done.
Lordship,
As per your request.
Lordship. So, Your Lordship, my withdrawal was accepted by Calcutta State Transport Corporation.
In 2006.
you want to revert back to.
Yes. Lordship.
Square one.
Lordship, I'm coming one by one. Lordship.
বল
তুমি এত কি বলো না? তুমি বসো। Now, your lordship, what happened? In 2006, your lordship, let me come. He made an application praying for pension. Kindly note the date, your lordship. 6/1/2006 is annexure P6, page number 24. Lordship, come to annexure P6, page number 24. Prayer for pension by the deceased employee of the Calcutta State Transport.
Page 24.
That's page number 24. P6. Lordship.
Economic disadvantage. I was.
Prayer for pension. Lordship, the kindly come to next page. Prayer for pension. Now come to next page. What CSTC has done. Lordship, page number 27 or 25, sorry, 25 P7, your lordship.
Yes.
From the accounts officer pension cell to Mr. Umashankar Chakravarti, deceased employee. In connection with the above, I am directed to request you to please deposit the amount of employee share of contributive provident fund and the excess amount of gratuity which has been drawn by you after retirement to entitle yourself under pension scheme as cited above if requisite option properly exists. So he said the CSTC informed him that if the option exists, your lordship have shown that option was exercised, it was admitted. So they want me to deposit the excess payment.
Yes.
Lordship, on 10/2/2006, in reply to my letter. Now, your lordship, kindly come to the next annexure P8. That is, the date is 19/6/2006. I wanted to know how much the quantum of money I have to deposit to get the pension. Lordship, kindly come to page P8 and page number 26. I wanted to know the quantum.
Calculation, yes.
Calculation, so that I can, because I was very much eager, because at that point of time.
Then it was turned down.
Yes. Lordship, now I died. The petitioner husband died. So, your lordship, the petitioner, here the petitioner, the widow, she made an application. I was told by corporation that your husband is entitled to get pension. You need to deposit the amount, this excess amount. I said, yes, I am very much eager. Whatever I got, my husband got, I am eager to refund the money, the excess gratuity and the employee share of provident fund, which I am not entitled to get because I opted for pension under the state scheme. So, I made a representation. So, that representation was not considered by them. Lordship, till date. Now, your lordship, my last submission before your lordship, last but not the least, your lordship, the Supreme Court on 8th of May 2023, your lordship, the apex court passed an order in Ashit Chakraborty's case, that was also my case, your lordship. So, it went up to Supreme Court. So, it said that whenever, as per regulation 6(1) of the DCRB scheme, you have to exercise your option to come under the purview of DCRB scheme. And that option is final because 7/7/2001 this government memo said you cannot re-opt, you cannot opt out from the said bench, from that scheme, your lordship. This is the order passed by the Honorable Supreme Court. When the option is there, you have to, this is the duty of the employer to make you come under the GPA. So, there's a direction to give the pension. So, your lordship, my respectful submission before your lordship, as my husband opted for pension, I was asked by the corporation to deposit the excess money. I am eager to deposit the excess money, whatever with interest, because there's a direction by the Supreme Court that you have to refund the money. They will calculate and give you the details that this is the money you have to deposit with interest. And the petitioner should deposit the interest, and within a month, they will release your pension, it's current pension, and the arrear pension they will release with 6% interest. Because I have to give them the excess amount with 6% interest, and they will give me the arrear pension with interest. So that was the view of the Honorable Supreme Court, your lordship. So my respectful submission before your lordship. Now, at this juncture, your lordship, I am.
But if it is a case of foregoing your right to get pension,
no, your lordship,
by making an application by making an application which was accepted, then you are stopped by conduct.
No, your lordship, that can't be because the Supreme
It's an
Court has
waiver,
said that.
waiver of your right.
No, your lordship can't be. Because your lordship, the government memo of 7/7/2001 says that I cannot reopt.
Why you did make application to
Lordship,
withdraw the pension?
at that point of time, the pension was irregular and I got in financial crisis, so made an application. But yes,
But
yes,
you cannot blow hot and cold in this.
lordship, that is not the so. How can they after?
Is it a same case?
2001?
Ashish Chakraborty's case is the same case. The Ashish Chakraborty withdrew pension, surrendered
No,
pension.
but in Ashish Chakraborty's case, what happens, your lordship? I tell you.
I am asking you in Ashish Chakraborty,
He did not withdraw his option.
then,
but he made
then
it
how it is applicable?
EPF. EPF is the same thing.
Then
EPF
how it is applicable in your case?
Because it says the regulation says
Yourself has applied for withdrawal of pension,
lordship
surrendering of pension.
Lordship, that can't be because 7/7/2001 government memo said I cannot reopt. Whenever if I can withdraw
And
the
on
option, you cannot
humanitarian
accept
ground,
that.
it was accepted.
So, your lordship, how can that be accepted when the government memo says that you cannot have that right to reopt or come out from the option? And Ashish Chakraborty's case, whenever you say that the option is there, so it is the duty as per regulation 64 says that is the duty of the employer to convert you from CPF to GPF. So it's the same case. And your lordship, the Weber, acquiescence, estoppel, every point has been taken by the Honorable Supreme Court, your lordship. In Ashish Chakraborty's case also, he filled up the form of EPF, that is Employees Provident Fund, 1995. That is applicable for the CPF employees, your lordship. So in the light of this government notification, that cannot be done. That cannot be withdrawn. And my withdrawal cannot be accepted also. Because it was the advice of only an advocate, but the government memo says otherwise.
No, advice of advocate, please don't make this submission repeatedly. I deprecate this practice. It is based on your application, madam.
Lordship, the government memorandum says 7/7/2001.
What is the, please read the letter in Bengali, page 16. Please read this letter. You are making allegation against the learned advocate, senior advocate who has advised to make payment. Please come to page 16 and read it. Please read it loudly. Let us hear this.
লর্ডশিপ, আপনার নিকট আমার সবিনয় নিবেদন যে অন্যান্য কর্মচারীর মতন পেনশন লইবার জন্য অপশন ফর্মে সহি করিয়া অফিসে জমা দিয়েছিলাম। বর্তমানে আমার পারিবারিক অর্থনৈতিক সমস্যা এবং অন্যান্য অসুবিধা থাকার দরুন আমি পেনশন লইতে ইচ্ছুক নই। আমার রিটায়ারমেন্টের তারিখ 31 জুলাই 2004। বর্তমানে আমি নীলগঞ্জ ডিপোর অধীনে পরিচালক হিসাবে কাজ করিতেছি। আমার পরিচালক নম্বর 5632। অতএব মহাশয়ের নিকট আমার বিনীত প্রার্থনা যে যাহাতে আমার পেনশন অপশন ফর্ম উইথড্র হয়, আমার সুব্যবস্থা করিলে কৃতজ্ঞ হইব।
So where is the wrong in advice of the learned advocate?
Lordship, I'm very sorry. I don't mean to say that. For financial crisis, I did it. But this is against the government memo.
When there will be financial crisis, you pray for withdrawal of pension, surrendering of pension, and there will be no financial crisis. You will pray for release of pension.
They should not reject they should have rejected my application that you cannot withdraw the option. Maybe you're having a financial crisis. This ordinary bench's honorable court passed an order. In the light of that, in that case also he withdrew his option.
But Mr. Bihani, come to page 25. Page 25 is in favor of the petitioner. In 2006, request you to please deposit the amount.
Yes, I have seen that. But I'm not going to the other points. Let me be restricted to what has fallen from your lordship. Now kindly sees that this was in 2006. Now, my lord, the husband of the petitioner dies in 2007. This was not acted upon. Now, my lord, in terms of the withdrawal of option, my lord, the contributory provident fund and gratuity, all dues have been paid. Now, in 2025, after his husband is died in 2007-25, he comes up and says, I had done that very well. I paid for withdrawal very well. I have again paid for this. So now you don't know, this is complete approbation, reprobation.
No, but the thing is this, it was responded by the department positively with an affirmative note.
Yes.
That yes, you refund the amount with interest
will release the pension.
No, but that was in 2006.
Yes.
Now she has,
So why
she has
you are
got
not giving
everything.
calculations that this is the amount along with interest? Submit it, will pay.
No, but now she has got everything. She has got all the retirement dues.
Yes, that's why this letter was issued. When this order was, this
No.
letter was issued
No,
on
this cannot be. Well, I tell you, Lordship, this was
10th of February 2006.
Now the husband
I am
of the
directed to request you to please deposit the amount of employer's share of contributed provident fund and excess amount of gratuity.
Lordship, retired in 2004.
2004
That's
retired.
right. No, but this was never acted upon by the petitioner or subsequently.
No, I made an application.
But now in
Since then, this was the response from accounts officer pension cell.
Correct.
So then where is the difficulty if this contributory provident fund and excess gratuity is paid with
now
interest?
possibly
You calculate the amount and intimate it.
I tell you, Lordship, possible. I'll take that instead, but possibly now that is become a little too late in the day.
But is there any time constraint?
But
is there any time? Tell me that if
I do not know. But I'll
there
be
is
venturing.
any last date after that in case of teachers in terms of Bhuitto's case, special bench judgment, judgment in Abhijit Bhuitto's case, there is a time constraint that within 6 months it was required to be done. Within 3 months it was required to be done. But that is why I am asking you, in case of employees of Calcutta State Transport Corporation, is there any time limit fixed?
No, I do not know. I am candid, Your Lordship, I do not know. But kindly see number one.
If there is no time limit fixed, then where is the difficulty in giving the calculation for making payment so that petitioner get pension as others are getting?
But
after all, it's a case of family pension.
Welfare, I understand. But my Lord, kindly visualize. I'll come back with that. Kindly visualize this. I make an application that I do not want pension.
That is what exactly court has asked.
That is why I did not repeat it.
That if there was no letter in the line of 10th February
There would have been no
2006,
case.
question would not have
I have
arisen.
understood.
But since this is a letter dated 10th February 2006, whereby authority decided, yes, since you have applied for, give the excess amount along with interest, then we will grant pension. But subsequently, representations were made.
No, kindly, I'll come back. But
By
kindly,
the
I'll come back.
widow
But kindly
that,
take.
please let me know
Yes,
that what is the amount which is required to be
I'll
paid.
come back to that. But kindly takes the trouble of taking the next page, the reply.
Yes.
আমি একটু বলি তুই ততক্ষণ বললি with reference to your letter bearing such and such in connection with the above subject, I am to state that I retired with effect from such and such. Hence, about 2 years have elapsed in the meantime. I presume that my pension all amounts from my retiring date will engulf and neutralize the entire amounts which I have drawn. This was the reply.
Hence, about 2 years.
This was the reply.
Next para, Your Lordship.
আমি একটু শেষ করি বাবু, তুই তো এতক্ষণ বললি।
So therefore, it is it was responded that there was automatic adjustment.
That's right.
But if you are submitting, no, it is also, it can be presumed that no, that is not the correct stand. That is not the correct thinking. So far the employee is concerned, retired employee is concerned. Now today she is submitting that if you deposit, she is willing to deposit the excess drawn amount or the amount which was paid towards contributory provident fund as well as gratuity along with interest.
Yes.
I'll come back with instance. That is not the subject. That was not the averment in the writ petition.
Yes, that is precisely the prayer made in this petition. That grant me pension. Pension can only be granted provided this repayment, this refund is made along with interest.
Very well.
Only point which I am asking you that it is there in case of teachers that there is a
outer limit,
time frame fixed.
Outer limit.
Beyond that, it is not permissible. Now, is there any provision relating to fixation of period within which this exercise is required to be
made.
The original exercise has to be done within 6 months.
But that was diluted subsequently.
No, that is not. He made it
Employees were subsequently permitted
No,
to.
anyway, she made it. His late husband made it within 6 months, so that is all right. But I'll have to take back.
Yes, original option was exercised within time.
Within time.
Then there was a prayer for surrendering
Correct.
pension.
That was allowed.
That was accepted.
Accepted.
Now the widow comes up and says, no, grant me pension, I am ready to refund the excess amount with interest.
Well, one question, my lord, is the time frame.
And
the second question is that if I can do it twice.
This fact is coupled with this letter dated
The P7.
A
That-
deceased
that
husband
is
also makes a prayer for pension,
No,
your
my
lordship.
lord, then let me come to the Supreme Court.
In 2006,
letter.
husband also made a prayer for pension, your lordship.
P7, right,
P7.
page 25.
But as far as this honorable Supreme Court
Make the calculation,
Lordship,
let it
give
be
it to
informed to the petitioner if
I have
petitioner
to
is
take
willing,
instruction.
grant pension.
No, I have to take Baba, you shanto hai. I have to take instructions on two aspects. Number one is this was a foreign prime lordship. Number two, but if within the four corners of the law, I can do it twice again. Accepted, then again refunded. Again, I can whether I have the power to do that.
But even after surrendering pension, this letter was issued.
Oh, that was a welfare scheme.
Yes, that should be the correct approach.
That's right.
Yes, that should be the correct approach.
That's
It's a
right.
case of pension.
That's right. It's a welfare approach, my lord. That is correct. But my lord, as far as the honorable Supreme Court's order is concerned, I have
So
the
it should
judgment.
be construed
is the-
liberally. So far pension is
Yes,
concerned.
constituted, but the lordship can do that. Whether I, as a statutory authority, have the power to do that. Well, kindly grant me some time at this outer limit. I'll come back to your lordship. If it can be done, if
file
it
a
can be done.
report disclosing the amount which is required.
Lordship.
Baba.
Within 2 months, I will give it with interest, your lordship. My instruction is that as early as possible, they will give me the calculation
Well, may I?
with interest. So on the condition is their lordship. They will release my family pension, and area they will also carry 6% interest.
Well, lordship, remember, I do not know if he's practicing anymore, Mr. Mihir Lal Chakraborty, advocate.
Yes.
Well, once I was in court, November 1, I was very junior. And the other side was arguing a lot. I asked Mr. Chakraborty, sir, you will not say anything. But he had told me one line, ignore him, it is juvenile exuberance. But may I do this? Lord grants me a very short time. I'll file a report with the calculation and also with the aspect whether, my lord, there is an outer limit as a foreign premier lordship. I'll do both. But as far as the honorable Supreme Court's order is concerned, well, I've come with it, this doesn't apply here.
Husband of the petitioner was an employee of Calcutta State Transport Corporation who retired on superannuation on 31st July 2004. In spite of exercising option within time by the husband of the petitioner to avail the benefit of pension, vide letter dated 14 January 2004, petitioner, video letter dated 14 January 2004, employee expressed willingness to surrender the pension and get benefits under the contributory provident fund scheme.
No.
Stop.
এটা আপনাদের
আমাদের জন্য রেখেছে।
না না তাদের জন্য কিছু দেয় না
Such prayer of the employee was accepted by the concerned authority of Calcutta State Transport Corporation. Vide
অন্য কোর্টে আছে।
memo dated 29th November 2004. Consequently, petitioner received benefits under contributory. Consequently, employee received benefit under contributory provident fund scheme. Next paragraph. Thereafter, retired employee Vide letter dated 6 January 2006 requested the concerned authority of Calcutta State Transport Corporation to release pension on adjustment of sum SUM along sum which was paid under contributory provident fund scheme. Now, which was paid towards contributory provident fund and gratuity, and it is also gratuity stop. Today, learned advocate representing the petitioner submits that petitioner, being the widow, is willing to refund the amount along with calculated interest for availing the benefit of pension. Next paragraph. Mr. Bihani, learned senior advocate representing Calcutta State Transport Corporation, has prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands adjourned till 19th November 2020. Obtain instruction come.
I'm not filing it.
Not at this stage. If it is very well, come back with the
report
instruction. Anna, at a line tele add kore daw. Concerned authority of Calcutta State Transport Corporation shall also be at leave to file a report disclosing the amount payable by the petitioner to in favor of corporation in order to avail the benefit of pension. Longer time is required.
Slightly, and my lord, also on the aspect as my lord, on related on the allied aspects, because I'll also take instruction in that report with regard to the timing, if at all.
25th November.
And the timing also indicate in that report itself. Statutory, থাকলে থাকবে, না থাকলে নেই।
Your Lordship, I'm for respondent number 1 to 3 in this matter. Already called 14.
15.
Item number 115.
Your Lordship, I'm for respondent number 1 to 3 in this matter.
Yes. Yes.
Affidavit on behalf of the petition. This is the
1 to 3. You are representing. I respondent number 1 to 3.
Yes, Your Lordship.
What about other respondents? No. There are 3 respondents.
3 respondents only.
Yes, yes.
But petitioner challenging the order of dismissal from service by the concerned BSF commandant, and my lord, subsequently my appeal pursuant to the direction of this honorable court under section 116(2) has been rejected by the authority.
What is rejected?
My statutory appeal. My
disciplinary proceeding.
No, my lord.
Appeal for relating to what?
Appeal actually, my lord, the petitioner.
What was the initial order or original order?
I'm sorry. My lord, the petitioner has been appointed as a constable in BSF, my lord. My lord, subsequently, kindly come to, my lord, page 24A, my lord. 24A, my lord, dated 20th July 2024, my lord. My lord, page 24A, typed copy, my lord. Now, the proceeding was initiated against the petitioner under section 40 on the ground stated therein. My lord, after conclusion of the proceeding, the petitioner was held guilty of charge and awarded punishment to
Where from you are reading page 24A?
24A, my lord, capital. My lord, just that page, type copy, my lord.
Typed copy, yes.
My lord,
Paragraph?
Paragraph 2.
Yes.
My lord, petitioner was, the individual was tried summarily for the charge under section 40 of the BSF Act, and the 40 of the section 40 of the BSF Act is relates to act prejudicial to good order and discipline of the force, my lord. My lord, the contents of the charge has been read over in the first paragraph, my lord, on 3rd June 2024, first paragraph. This is the content of the allegation, my lord.
Just a minute. Yes.
So petitioner was found guilty under section 40 and directed to suffer
Regardless imprisonment
for 28 days, my lord. And in RI force custody.
In force custody, yes.
I was immediately placed under the civil prison as directed by this order. My lord, the next page, that is 24B, is the roster which shows that I was taken on, my lord, the civil prison.
Yes. So now, what is your prayer?
My lord, initially this has been done. All of a sudden, my lord, on 24th of July, this conviction or sentence has been set aside by the authority itself without any communication or without anything, my lord. The authority has set aside this sentence, though by that time I have, my lord, served out 4 days custody from 20th to 24th. My lord, the reversal of sentence was done on 24th of July 2024. Thereafter, I, my lord, assumed the duty. My lord, in September 10, 2024, a notice was again served upon me for the retrial of the same allegation. My lord, that is at page 25. This is the notice, and the next page is the charge sheet. My lord, a charge sheet has also
fresh charge sheet was issued.
Fresh charge sheet was issued. Now, in 26, the charges were framed. In first charge, the section 40 similar like the earlier charges. Second charge is under section 40. Third charge is under section 20E, neglecting to obey local order. My lord, after receiving this charge, I made a representation to the authority, which is appearing at page 29. And charge sheet is appearing at page, my lord, 26. The second charge sheet.
Yes, then based on this charge sheet, what steps were taken?
My lord, that is at page 33, annexure P7, my lord. Again, a retrial was conducted. And
what was the outcome of this retrial?
To be dismissed from the service.
Against which you preferred appeal?
Against which I preferred appeal. That was not addressed within time. I came up before this honorable court. Since the statutory appeal was pending, this honorable court has directed the authority to consider my statutory appeal under the statute, my lord. My lord, I have communicated the order in presence of the Learned Counsel appearing on behalf of the BSF that was passed, my lord. My lord, finally, the statutory appeal that I have preferred has been dismissed. That is at page 163, my lord.
So challenging this, you have come.
My lord.
So what is the scope of passing an interim order at this stage, at the motion stage? Let the issue be decided on exchange of evidence.
My lord, that though there is no, my lord, but
there is no scope. Where is the final order of punishment? Dismissal from service?
That is the page 33, my lord. This is the actual order and the subsequent, my lord, I have only 2 points, my lord. One is under section 79 that I cannot be punished for the same offense for twice, my lord, which is specifically stated in the act also, BSF act also. And my lord,
now if you would have undergone that 30 days custody,
28 days initial.
Where is that order?
My lord, page 24A.
Page 24A.
Yes, my lord.
28 days regardless imprisonment. So if you are kept in custody of BSF for 28 days, then you would have been permitted to resume duty.
My lord, actually I had resumed the duty.
That you have resumed duty since that order was set aside. I am asking you, think about a situation where this order at page 24A was finally given effect. You are kept under custody for 28 days. Custody of BSF. After that, whether you would have been permitted to resume duty?
Certainly. Certainly. Because in 24A, no other punishment has been imposed upon me. Over the same self, my lord, charges.
So why you are coming after completion of second stage of second proceedings in its entirety?
My lord,
you could have approached at the time of issuance of second charge sheet.
My lord, I have.
Or at the time of commencement of second disciplinary proceedings.
My lord,
setting aside previous order.
May I answer this question, my lord? Actually,
you took chance if a better order can be passed.
No, my lord. No.
Ultimately, you suffered an order of dismissal.
No, my lord.
Then that was appealed against.
I immediately made representation upon receipt of the, my lord, the second charge sheet, my lord. And my lord, act says, as per the BSF act says, my lord, until and unless I address my statutory appeal under section 116(2) read with the rules, my lord. My lord, I cannot prefer.
That's true.
226
but
application.
When this charge sheet was issued,
yes, my lord.
Setting aside previous order of
sheet,
punishment, which is at page 24A, at the time of commencement of proceeding, why you did not approach this court?
My lord, I have approached the authority, my lord, and my lord, one more thing, my lord, the charge sheet does not state that the earlier proceeding has been set aside. But
earlier is now the second proceeding, which was commenced based on charge sheet dated 10 September 2024, has been concluded logically. Now there is no scope for passing any interim order.
My lord, once, my lord, I know.
You accepting initiation of second disciplinary proceedings based on charge sheet dated 10 September 2024. You participated in the inquiry proceedings, appeared before the inquiry officer, and then final order of punishment was passed, against which you preferred appeal. So at this stage there is no scope.
My lord, I may.
So where is the order of dismissal?
In statutory appeal, my lord.
No, order of dismissal, order of the disciplinary authority.
Dismissal is 33, my lord.
Inquiry was held.
Thereafter, summary proceeding was, my lord, conducted. I have annexed because I, my lord, applied for the documents placed in such summary proceedings that I have also annexed, my lord, in the petition. After the my representation, this has been annexed, my lord.
Page 33.
33 is the principal dismissal order, my lord.
And the order of the appellate authority?
Order of the appellate authority. And here, my lord, order of the appellate authority is at page, my lord, 163, my lord. '63, my lord, 163, my lord. And continuation of the order is onwards, my lord. And you see the
Just a minute. But it has been addressed to the advocate.
The order has been communicated to me since I have sent the, my lord, order sheets of the Honorable High Court, my lord. 164 onwards, the order sheet.
It's a mere communication. Where is the order?
My lord, 164 onwards, my lord, last page, sorry, my lord. Sorry, extremely sorry. 170 last page is to the above disposal of the statutory petition in compare 170 third page, paragraph 32, my lord. Accordingly rejected.
Yes, why there was deviation after issuance of a first punishment? Why subsequently a fresh proceeding was initiated?
Actually, your lordship, the first charges was under section 40 and it was quite lenient in nature. So it was found to be too lenient and the DIG BSF decided to get the thing fresh and a fresh trial and that took place. And they participate wholeheartedly in this particular proceedings before the summary security force court proceedings on 2 charges.
Once a proceeding was initiated and an imprisonment for 28 days in the custody of BSF was issued, punishment order. The petitioner was taken into custody. He was in custody. She was in custody for 4 days.
4 days.
Subsequently, that order was set aside.
That was set aside.
Suo moto, that order was set aside.
Yes.
And thereafter a fresh charge sheet.
No, the same charges were
and dismissed from service.
Actually, your lordship, he was subjected to your summary proceedings as per.
You have surrendered. You have submitted to, before the jurisdiction of the authority in the second proceeding. That is the main problem.
My lord, may I
Yes,
say,
that's what I'm asking.
my lord, may I say two submission only, man. my lord, the day on 24th of July 2024, when my first,
You could have questioned issuance of second charge sheet
I have questioned to the
at that
authority,
point of,
Yes, that's what I'm telling.
not before the authority, before the,
my lord, I have questioned
at the material point of.
because I at
Yes,
that
sir.
point of time, and one more thing, my lord.
And court directed, thereafter you preferred an appeal.
My lord,
Appeal was kept
that is the
pending.
remedy I
Then
need
you
to
have
exhaust.
filed a writ petition.
My lord, I
In
need
the
to
writ
exhaust.
petition, this court coordinate bench directed to dispose of the appeal.
My lord, that is the my lord
Your-
remedy. My lord, may I say two things, my lord?
Your
Only.
Lordship, even the section 75(1) is also
affidavit
been,
service filed
been
on behalf of
complied
the
with.
petitioner is
Does
taken
not
on
bar
record.
disciplinary
Next
action for distinct offences even if they arise from some common transactions.
My lord, when my
And there are
urgent
two distinct
interest
charges,
set aside,
section
then
22E
in
and
that
The writ petition,
section 40.
order of punishment from dismissal, order of punishment of dismissal from service, dated 8 October 2024, and order of the appellate authority dated 5th June 2025 are questioned. Stop. Petitioner was working in Border Security Force and was dismissed from service. Stop. It is also contended on behalf of the petitioner that order of the disciplinary authority dated 8 October 2024 was affirmed by the order of the appellate authority. Stop. Next paragraph. Respondents are represented by learned advocate who appears on virtual mode. Next paragraph. It appears that issue involved in this writ petition needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Your Lordship, may I add one thing? He had never raised this issue of the double jeopardy. He has mentioned in the four corners of the writ petition also.
Grateful, man.
Grateful, Your Lordship.
The Lordship will not call next matter.
No, this is the last matter for that.